Good morning. Welcome everyone here in the second day of World Litigation Forum 2023 in Dubai. Just let me introduce myself and our firm, BSA Ahmed bin Hazim. My name is Asim Ahmed, partner and head of litigation in the firm. BSA is delighted as a UAE headquarter regional law firm to welcome our colleague who is coming from abroad to be part with this very important event. And we are in BSA Ahmed bin Hazim as Middle East regional law firm with 9 offices across 5 countries, UAE, Saudi Arabia, Oman, Iraq, Lebanon. We have been established here more than 20 years. During this period, we have been practicing and be part of very important cases in UAE and in Dubai. And all these practices has given us very good knowledge and in different sectors of law. And we are providing as BSA all legal services. And just let me host you all and give our intention to provide you with all information and suggestion about anything you need if you are staying still with us in UAE. And we want to share with you our celebrating the 20 years of practicing in UAE. And for that, we have been as a part in more than many cases, largest cases in UAE. And by that celebrate, we intend and we are proud to consolidate this knowledge into a precedent book spanning 20 years of our knowledge in practicing in litigation. And with our partner, Sadir, we proud to provide our book in which we choose more than 20 cases being handled in UAE. We have been a part of these cases, and also we proud to inform that we got a success results in all these cases. These cases has been working very hardly with our colleagues who has a good and large experience in litigation. And one of our colleague who is being part of this success 20 precedent cases, our colleague Mr. Shaban, who is being part and also wrote the book. And with our partnership with Sadir, Mr. Rami Sadir, one of the largest express in the region, we have produced this book, and we are very proud and we are be very pleased if you take a note, and if any one of you take one of this, so as we can share together the knowledge. And we are ready to hear from you about outcome of these cases and any information and any requirement and any inquiry about these cases. And we want also finally to thank the organizer of this World Litigation Forum, who give us this chance to share together our knowledge, our legal knowledge, and to be also have these nice people and to meet them in many time in this event. And we just want Mr. Sader to give you idea about their working.
It won't, good morning, ladies and gentlemen. My name is Rami Sadeh. I'm the fifth generation of the oldest legal publishing house in the Middle East, established in 1863. So we're happily having our 160 years of establishment this year. Well, frankly, I won't talk much, but why BSA and why 20 and 20? First of all, firms like BSA, they stop being time tellers. They start being clock builders. And it's not easy to build culture. And in a country as fast as the UAE, I think everyone in the UAE community is working hard to make the UAE a different place when it comes to its legal system, its evolution, etc. And this being said, building a culture is not easy. So practically, I know how much time the BSA team did to choose 20 cases as flagships. Plus, let me tell you, this is the first book in the UAE and in the Arab region which has the 3 levels in the litigation, where we see the first instance, the appeal, and then the cassation or the high court. I cannot thank all the BSA team, but definitely I have to thank Clara for bringing this to life. Mr. Asim and Mr. Sha'bain, thank you so much for all the hustle. Just to summarize, building a culture needs 3 pillars practically. It's knowledge, accessibility, and community. So whenever we have a community working together to have the information it's gathering accessible through its knowledge, I think this is how we can flourish when it comes to legal culture. Thank you so much, and I'll give you back the floor.
Yeah, we don't want to take any time from you. Thank you very much. And just our book is out in this with stand with our marketing team. Anyone, please, we invite you to take one of you while you are leaving. Thank you very much.
And with this, we will be moving to the session 1 of the day, which speaks about. Thank you so much. So with this, we will be moving to this session 1 of the day, which speaks about the legal risk during disruptive markets and business challenges. And our eminent moderator and panelists are, rather I'll speak about the moderator. She's Sabrina Noreen Malik, who is a consultant solicitor, negotiation expert, Alexander James Solicitor, United Kingdom. Then our eminent panelists are Karim Hamdi Sior, who is a legal director at Al Ghurair, Dubai. We have Renata Bazanskin, who is the General Counsel, Olin Litua. And we have Munaf Farid, who is the Managing Director at Hatch Consulting, Dubai. Then we have Andrew Hart, who is a partner at Hart Gills, Solicitor, Notaries, Hong Kong. So with this, I would like to welcome our panelists and moderators for the session 1 of the day 2.
No, Karim.
So,
Karim,
okay. So with this, I would hand it over to our moderator, Sabrina Noreen Malik, to please take it forward from here.
Assalamu alaikum, good morning, Sabah khair, Dubai, nice to be here. Thank you to World Litigation Forum for organising this event and bringing the legal community together. Today we're addressing a very important topic, something that's been more so since the pandemic. So my question to you all is, what's the biggest business risk you've ever taken? Risk is something that can be mitigated with the right strategies and plans in place. And this is what our international team, our international panel today are going to address. So long as your business has the right mitigation strategies and a good business plan in place, risks can be eliminated. However, in the pandemic, we realized that not all risks can be eliminated and not all firms are 100% risk-free. You could have staff issues, you could have supply chain issues, you could have lease issues, paying your rent. You know, you just don't know in which direction something's going to come, but it's all about mitigation. And once you've mitigated the risk, it's about the result, about analyzing the result and learning from your mistakes and how you can do things better. Because although we've just come out from a pandemic, there's no guarantee that we might not have another wave. There's no guarantee we may not face another critical situation in the near future. And so for these reasons, we need to be alert at all times. And the pandemic, what that taught us is that remote working is accessible, so long as we've got the right data protection, strategies in place, working dynamics in place, and ensuring that the staff are fully supported. So that was something that came into light during the pandemic, and I will now pass on to our first speaker to discuss strategies and the legal risks arising from failures to comply with statutory and regulatory obligations. If any of the audience have any questions as the panel is speaking, please feel free to put your hand up and they'll address it. You do not need to wait until the end. And with that said, I'll pass you to Renata.
Thanks a lot. So for me, nowadays, the biggest challenges and for our company are compliance with sanction regime. As in our region, this is very hot issue. And if we do not comply with sanctions regime in accordance with legislation, EU legislation and our legislation, this contract is invalid. What does it mean? If we do not terminate this contract, even this contract is profitable to our company, then we might even lose the license to operate. As our company operates in 6 jurisdictions, Latvia, Lithuania, Estonia, Poland, Czech Republic and Canada, and we have 4 oil refineries. So this is really a huge risk. And recently we needed to terminate very profitable for us contract for electricity supply because the entity who provided the electricity is a sanctioned entity. So then we have litigation because we are asking to cover for this entity the losses we incurred because we need to buy electricity 4 times more expensive, and it's not our fault. So another item was that recently in Supreme Court also rendered award decision in which to sanction one of entity which is seller was ultimate beneficiary was sanctioned, and the purchase did not wanted to make the payment because he said that I cannot make the payment because this seller is sanctioned and bank did not allow me, and he asked the court to refuse him from liability to pay. Then of course seller went to the court and court said that if your counterparty is sanctioned, it does not limit you from liability to make payment. It only suspends obligation to make payment. So that's really, for me, it's important that in all contracts now, after February, we put like clauses where we say in case of entity is sanctioned, how we notify about termination, what are the proceedings. As in force majeure clause, we also put now sanction clause. Another risk, it's violation, as has been mentioned, of data protection, because if you violate data protection regulation, it's 4% of global turnover. So it's a huge fine. Another issue is about competition violation, competition laws violation. litigation, which is also 10% of global turnover. And also, if you're operating license business, so you need to meet all requirements in order not to lose your license. So when you look from the position of in-house, it's a really huge risk, because you operate in such environment where you need to really control, as a head of legal, all these major risks. And of course, there are risks if you do not contractual risk, as we talked yesterday about hardship issues, about force majeure, about there are litigation risks, but I divide these four main risks: sanctions, data leaks and protection, competition, and also the license, meeting of the license requirements.
Thanks, Renata. I'll now ask our esteemed colleague Karim to discuss rapid changes in the UAE laws and procedural code.
Yeah, thank you so much, Sabina. So this is a good question, and I would like to start by wishing everyone enjoyable and very wonderful having you here first. So my name is Karim Sour. I'm head of dispute resolution with Al Investment LLC. So I have been practicing litigation and arbitration for over 20 years now. So when I was invited for this, I found the topic to be very interesting, actually. Because the law of any law is to be flexible in order to try to accommodate the demands and the requirements of the market and any disruption which may affect the market from time to time. That's why, as we all know, there are two or three types of laws, which is regulation, then laws, then constitution. Regulation and laws are always tend to be flexible by the legislator in any territory or market in order to meet whatever changes in the market and whatever disruption incidents which are unforeseen at the time of if it's happening, so that it can encounter and tailor the requirements of the market at that time. For example, I can say that we are a very unlucky generation, because over the past 5 years, we have passed with many disruptive risks and legal risks that we have all faced, started from COVID-19, which lasted for almost 3 years. Then we just tried to have a sigh of relief for some time at the Bristol to find the war crisis. Then after that, we don't know what will happen. So in the past, like 3, 4, or let's say 5 years, since 2018 or 19 till now, we are facing crisis all the time. That's why laws are always there to try to meet this. I will try to be very practical in my speakership, because I'm coming from the field, as they say. I can say that the UAE legislator was very observant to meet all of these. And they started from, as you have all seen, from the beginning of 2022, UAE has made an overall changes in many laws. We have seen many changes, for example, in the labor law, new totally labor law which came into force in the early 2022. We have seen companies law, totally new one. We have seen penal code, totally new one. Recently, we have seen procedural code, very new one. Almost I can see it is an overwhelming and comprehensive overhaul in all the laws of UAE. The legislator was there to meet the disruption incidents which affected the market since the COVID-19 until now. I will just focus on 2 laws. I cannot cover all the changes that happened, of course, in all these laws. For example, we all remember in the COVID-19, when it started, around like 4 years back, there were many new regulations issued to put some employees in a hold, for example, or to put some employees on part-time regime and all of these, so that to try to meet. This is how the UAE legislature has interfered to meet all these disruption risks to the market, for example. If we shed light very briefly, for example, on 2 laws which very affect the life of each and every one in UAE, like every employee, like everyone in UAE, which is the UAE labor law, for example, to see very few significant changes. that the legislator was very observant to put in the law in order to meet all these risks. For example, in the new labor law, for example, of 33 for the year 2021, the law acknowledged for the first time the part-time and flexible working arrangements, for example. This never happened in the old law, for example. It was never there. The old law never provided for any of these arrangements. So now the new law acknowledged working from home, which we all like, I'm sure. The labor law, for example, acknowledged the part-time work, flexible work, which means working from home, but with the approval, of course, if the employer, and temporary work for construction projects, which I am coming from. We have many construction projects. We agree with an employee, for example, an engineer. We have a project for 3 years. This is only temporary. Once the project is done, we may say it is a sanction by. So, and he knows that, and so the law, the new law, acknowledges this kind of temporary works. Second very significant change in the new labor law is that now it is a fixed term. Unlimited term contracts are not anywhere existing in the new labor law. So the old law provided only for 2 types of terms, which is unlimited and fixed term. The new law provided only for fixed terms up to 3 years. It can be 1 year, it can be 2 years or 3 years. This is again a significant change to try to meet the risks in the market. A third very significant change is about the contract termination. The new law provided for the fixed contracts, it can be terminated on notice during the course of the term for a legitimate reason only. Only there should be a valid reason for termination. While in the old law, it only provided for termination without notice for the reasons of the FAM article of 120 or without reason at all for unlimited contracts, because in the old law, unlimited contracts were provided for termination either by the employee or the employer. Both of them, any one of them can terminate. The new law stopped all of that, provided only for fixed terms, and put mechanisms for termination. A fourth significant, for example, change in the new law of the labor law was the end of service entitlement. The new law provided that all of end of service entitlement must be paid within 14 days from the termination date. Otherwise, the institution will be fined between 5,000 to 1 million. The old law level provided for these. This is all of these things are to protect both, actually, to be honest, the employee and the employer from all of these risks and disruptive markets we are in, or we are experiencing from time to time. The last significant change in the new law is about the compensation for the unlawful termination. Under the new law, the concept of wrongful or arbitrary dismissal has been removed. There's nothing called now wrongful termination. Instead, the law provides that an employee termination is unlawful on only 2 reasons. The first reason, if the termination was as a result of the employee filing a serious complaint against the employer, or if the employee filed a case against the employer which is successfully upheld. Only in these 2 cases, the law provides that the termination is unlawful. If the employer terminating the employee for any of these 2 reasons. And this is significant change again, because the old law provided only for compensation for wrongful dismissal where for reasons which are not related to work. The second law, which is very quickly I will shed light on, is the new procedural law, which was issued very recently. Actually, the procedural code is being changed from time to time within the last 2-3 years, many times to meet the risks in the market. For example, for the execution, now it is only 7 days for the litigation for execution. But in the old law, it was 15 days. Just the legislator wanted to expedite the process of the execution. The second significant change now is service outside the jurisdiction. The third one is checks. Checks are now, bouncing checks are now enforceable immediately. Once you have a bouncing check, you can go to the execution court, have a writ of execution, which we call it sanat tanfizi, go and file immediately before the execution court without any need to go to file a case first, then go to execution, which is very fast now. And one very significant change is about the appeal period. Now the cassation court period to appeal is only 30 days, while in the old law, it was you have the right to appeal before the cassation within 60 days. Now it is only 30. I just wanted to shed light and to give example for only for these 2 laws, To give you examples, why is that? Legislators all over the world, but I just give an example for the UAE legislator, need to be very observant all the time to meet all these disruptive legal risks. So laws needs to be changed all the time to meet all of these risks and disruptive markets. Thank you so much. Thank you.
Thank you, and it's great to hear. That was a very well discussed issue, and emerging risks are always in place, and strategies need to be enhanced at every stage. And quite rightly said, we've come out of a long-term pandemic where remote working was the norm, and then coming back into the society and office-based work, whether it's part-time or full-time, it's something that you had to then get used to again. And then after that, rightly said, the war issue, and then we've had inflation increase, and in Europe we've now got the energy crisis as well, where energy prices have soared, doubled or sometimes tripled. And again, it's business strategies you need to put in place. So the business that are affected now by the energy crisis, they've got to weigh up, do we keep employees in place? Do we keep the premises for rent? Do we downsize? Do we just implement remote working again? So businesses have to think of these strategies at every stage. You can't just think your plan is there and in 10 years it will still be the right plan for you, because each week, each month, each year, there will be some new development, and it's very important to keep on top of the risks in order to mitigate them as much as possible and to keep your costs down and your profits up. So with that said, I'll pass you now over to Mona, who will continue with the discussion. And again, any questions, please do feel free to put your hands up. Thank you.
Hi, everyone. My name's Muna Farid. So I think it's a fantastic topic that I've gotten the opportunity to be part of, because I think other than at least people of my vintage who've been around have seen their share of crisis. But I would say that today we live in a world in which rapid response is actually the norm, as opposed to something that you have the ability to think about and potentially prepare for and actually have outcomes predetermined. So I would say, by way of introduction, I was in-house. I've been in private practice. I've worked in both public and private sector, and have also worked from very mature global organizations all the way down to startups in multiple industries. So what I just want to share in terms of how do we deal with legal risk, how do we manage through crisis, and how do we anticipate disruption for the future is really through my personal perspective and my experience. So I would say that my perspective is that there is a slight distinction between risk and uncertainty. Risk is something, in my opinion, that you can anticipate. You have measured the outcome due to industry experience or your particular sort of world experience, or through external counsel, etc. So that's one. It's something you can calculate, anticipate, and hopefully mitigate and prepare for. Uncertainty is kind of what we're living in now. War, unanticipated events that kind of land on your desk, and you have to run 1,000 miles a minute to be able to either protect your organization from reputational loss from, or potentially from massive revenue or profit loss. So it's a question of how do you deal with either. In my experience, risk has been always about having SOPs, working with global organizations. If you've got a product recall, for example, or you've got a claim that you've made that a customer is challenging, in the world of sanitizers, how do you face a challenge that says, is that really 100% efficacy against germs, etc. So it's basically something you've anticipated, where a lot of people are there to support you, and then you have a response, and hopefully that's the end of it. If it goes to litigation, you at least can do some prediction around what could be the outcome, could there be settlement, what's the precedent, and move in that direction. In uncertainty, whether it's sanction, whether it's war, whether it's oil crisis, whether it's financial crisis, you really have to think on your feet. Again, there's an impact with respect to whether you're private sector, you're public sector, you're large, you're small, you're global, you're individual, you're local. And based on who you are, that impacts also how you respond and the expectation of your response. So one could be in a scenario where you're a financial services entity and you've got a crisis like we have all experienced, I think, in this room, the first financial crisis in 2006, 2007. Well, if you look at a company like Lehman, something nobody could have anticipated would have happened to a company of that size and scale and reputation. How would you deal with that situation? What would be the protocols? First, you would check internally quickly in a case study. You would make sure that do you have the right systems and processes, because that's your main line of defense against regulators. Second, and almost immediately, you would be on the phone or in the offices of the regulator to ensure that you're giving them the comfort that you're able to regulate yourself and with respect to the other, with the entity that you're dealing with that has an impact on your business, such as a Lehman Brothers. And third, you would ensure that, what would be the potential litigation or risk that you would be exposed to as a result of the action of a third party such as Lehman. So it would be all of those steps, making sure that you understand, first of all, where you stand. Second of all, make sure that's widely communicated if there's a direct risk from that entity to your organization. And third, you've taken all the very active steps of actually reaching out to those who can actually fine you and move against you in that particular perspective. And it's not against, it's really about mitigating that particular situation. In an uncertain situation, such as we've all lived through the last couple of years, what do you do? Well, depends again on the nature of the business or the industry that you're in. If you have a lot of exposure to supply chain, you need to understand how you're impacted. Look at other contractual situations. You would look at your contractual rights, for example, against suppliers. You would look at alternative sourcing. You would move quickly to see how you would be able to fill those gaps. Look at local manufacturing and local distribution, local suppliers. So those would be kind of the practical steps you would have to take in a supply chain situation. Alternatively, if you're in a product recall situation, it would be the same thing. What's the defect? Who's been harmed? How do you act? What's the risk? And then whom do you need to report up to? Does it have to go all the way to the audit and risk committee? Is it something, that your CEO can handle? Is it, which external specialist law firms would you engage to help you, prepare the defense, etc. So I think it always depends. And if you're a public organization, obviously you have a lot more regulatory and legislative exposure, so you have to anticipate that and get ready for that. If you're a private organization, your reputation, your brand might be at risk, so you have to anticipate that and work on that. Similarly, in a world where climate is a big issue and we're talking environmental, ESG, reporting, compliance, lots of focus is going to be on that and hopefully continue to be on that topic. Again, what happens in an environmental spill situation? How do you manage that crisis? What if you're a global organization but your local rules have not caught up? Because laws are changing all the time and they're having to respond. So often in emerging markets, et cetera, sometimes you have to be sort of the standard bearer of the regulation, even if there's not a law on the book. So how do you respond in that situation? Do you comply to local? Do you comply to global? Do you create your own standard? So those are also very important things to keep in mind in uncertain situations. I would say, ultimately, risk is about calculation, about outcome determination, prediction, getting the right experts, such as all of you, around you, and making those right decisions, and communicating very, very collaboratively and openly to the lines of management that have to go up. Sometimes you can't involve management if there's a direct risk through that management decision itself. So you have to then look at what are your protocols in place to go alternative routes. And I'd say sort of in conclusion, we also have to look at what are the future trends. We've got metaverse coming, we've got crypto, we've got all the fallout that we're looking at now. Those are not necessarily crisis per se. They're market forces that we haven't taken into consideration and that are unprecedented. But I think all of us in this room who are in the legal field and litigation and compliance, we have to really be aware that they're going to be a whole different universe and raft of not only legislation, but also risks that are going to come and be associated with the rapid movement in those particular directions. Metaverse is a $3 trillion industry. So what's going to happen there? What's going to happen to your identity? What's going to happen to your privacy? What if somebody steals your avatar? I mean, really interesting questions that are going to happen. And I think all of us need to also be looking at those future trends, not just today. While the traditional risks will remain, the traditional aspects of our businesses will remain, I think all of us as business leaders also need to think that where is the future going to be for all of us? Where do we need to practice, and where can we be of value to our clients to anticipate some of that? Because these are areas that touch on every single industry. And lastly, I would say that if you look at risk and uncertainty, the sort of three things that come to mind is, are you clear in your understanding? If you're not clear, can you get that clarity through support of your legal community and your commercial teams? 2, are you in a position to communicate effectively and give people in your organization the ability to feel safe, that they can share openly with you, that you can conduct appropriate diligence, and that you're a safe pair of hands that will at least treat them fairly if wrongdoing has happened? So trust is very important. And 3rd, wherever possible, in your contracts, in your litigation experience, in your organizational behavior, you have to, and your training that you provide your teams, you have to constantly evaluate and post-evaluate and make sure that everybody, every single last employee who's around you, or your third parties, or your stakeholders, or your regulators are fully aware of the attempts you're making to be compliant, but also how that's an individual responsibility right down to the last person. So that's really all I have to say about the topic. I think it's very interesting times, and thank you for the opportunity.
Thank you, Mona, for all those golden nuggets. I really appreciate your input. I hope the audience appreciated it as well. And quite rightly said, challenges are immense, whether we are in the virtual world or in the real world. Again, in the metaverse, there has been an employment law claim when one avatar had harassed another avatar. And so how that will evolve and develop, the laws and legislations with regards to avatars, is going to be a very interesting concept as well. And I'll just touch upon the contracts issue, which Mona rightly raised. It's very important that you do have your contracts agreed, signed and dated. Whether that's in a business scenario or personal, you should never, ever, and as lawyers you would know, enter into any agreement without it being signed, dated, executed. Because once that's done, any disruption later or any disagreement later can easily be resolved by bringing the document up and just saying, this is what we agreed. But if it's verbal terms, then you've got to be very careful about how that relationship will exist. And sometimes it can be family you're in business with, and you've got to really weigh up and calculate the emotional and personal perspective as well that goes along with the risk of a business, because we forget as humans that there's an emotional element attached, particularly if you're involved in commercial and corporate work. It's high impact, high volume business transactions, and then emotional and a human touch is not there as much, and you forget that these relationships are actually very crucial and very important to build and develop and blossom. So always keep that in the back of your mind. And I'll finally ask our panel member, Andrew, to give his input on this amazing topic. So Andrew, the floor's all yours.
Yes, thank you very much. You could say that I've been given the poison chalice, because you can see that I've come from Hong Kong, and whatever I say, I would like to go back there afterwards. So I'm going to be very careful what I say, and I'm not going to say anything more controversial than usual, but in summary, and I'll explain the background, I have been practicing as a solicitor in Hong Kong for 35 years, and therefore I was there before the handover, just soon after, in fact, Margaret Thatcher negotiated the joint declaration, and then the handover to China in 1997, and there's been about halfway through of the 50 years, just over, between the time where China has said that Hong Kong will remain able to continue to practice the capitalist way of life. I suggest that's where it's the vernacular of it. But I would say that although there have been challenges in Hong Kong in the last 3 to 4 years, and even before that, I have found that as a businessman and a lawyer in particular, I am able to continue my practice without any adverse interruption by the government. Which is also that sort of amount, and also the UK. And whatever the problems that Hong Kong may have faced, I'm sure we've all read and seen the news, and Sabina lives there, so UK is not necessarily the best place at the moment for the economic survival of the country, and particularly I think there are being implications, without being political, of the UK's decision to leave the EU. But going back to Hong Kong, as you may be aware, Britain ruled Hong Kong as initially a colony, and then it was known as a dependent territory for approximately 160 years. Now, as you probably also know, Britain managed to acquire Hong Kong in the same way as it's acquired other things around the world, not necessarily through the highest moral way, but through the Opium War, which Hong Kong, in fact, was given to Britain. Hong Kong Island and the new territory and Kowloon was given in perpetuity, but the rest of it were given for 150-year leases. But China didn't recognize any treaty that was signed before 1948, the revolution, and therefore everything had to be renegotiated. And although, interestingly, just going back to the time, Britain said they were going to preserve the position in Hong Kong, in view of the fact that 80% of the water came from China, all China really needed to do to negotiate was turn off the tap, and Hong Kong would then be in serious trouble. And I'm sure that you're all aware here how important water is to life and business and whatever. But going back to the most immediate time, we had, I think, two challenges. The first is, I think, similar to everybody else, which is COVID. And I think it's probably fair to say that COVID started around 3 years ago, beginning of 2020. We had another issue in Hong Kong before that, but the most recent thing in around the summer of 2019, where there were riots there, principally because of the introduction of a piece of legislation called the National Security Law, NSL, which was originally withdrawn, but then it came back again. It's okay. Yeah. Can anyone not hear me?
Yeah.
Perfect. If he gives me a microphone, I might start singing. But then everyone would walk out. But no, the position then was that the National Security Law came back again in 2020, and the two jurisdictions that seem to be most interested about Hong Kong are, first of all, America, and second of all, the UK. Now, going to America, they published this 10-page document in the middle of 2021, which basically gives warnings for people doing business in Hong Kong. And the position there is that the reality is they've got two main things that they are concerned about. And they say the risks there are, firstly, the risks, 4 different categories of risks. The first is under the NSL. The second is data privacy. The third is transparency of business information. And the fourth is exposure to sanctioned persons. Now, the fourth one is a bit self-serving because the sanctions are introduced by America anyhow. But I believe that the NSL is an issue. It's still going ahead. The law has certain points which are, I would say, offensive to people. But at the same time, as a lawyer, the way that I look at things is, all right, I was born in the UK, I've been in Hong Kong a long time, but I still feel that I'm a visitor there. I'm privileged to be there. I'm able to practice. I've got rights of audience before the courts, in fact, high rights of audience, so I've got the same rights as barristers to present cases in the courts. And I have found, personally, no significant difference over the last 3 years as I did before. And the thing that I would say that has been positive over the last 3 years is, first of all, and I think it's been covered already by various panel members, people adopt a more flexible working attitude. They work at home, they work from different locations, and in fact, you can often, you know, I don't know about the people here that have been traveled to Dubai. You don't necessarily tell your clients or people you're dealing with in work that you're not in Hong Kong or you're not in your home country, because you could then have a disadvantage in the way that you deal with things. But the other thing that has been an advantage for me particularly is no travel for 3 years. So you can imagine the amount of money that you save on hotel, flights, and various other car hire and other things. It's become a much more challenging thing, however, when the airlines have reopened, because I think everyone's found that the price of fuel has gone up and the cost of air travel is more challenging. Second of all, though, expenses have gone down. In terms of rent, there's been more supply of rent. There has been also rental accommodation, I should say, and there's been more staff available. There's been a number of people that have left Hong Kong, and I would say that that is unfortunate, but in some ways it's similar to what happened in 1997. People left and then they started to come back again, because particularly those that have gone to the UK, I shouldn't be so unkind about my home country, they realise that when they've lived in the UK for a while, it's not such a great place to live as perhaps they imagine it. I'm sure there are a lot of people here from the UK that would disagree, and I'm very happy for you to make your statements later. But I would say that going forward, the other main change that has happened only recently was the change in the COVID policy. Hong Kong was very, very restrictive, as was China, in the sense that they had basically a zero tolerance to COVID, and there was not any allowance for people to travel from Hong Kong into China without doing quarantine. That has been changed in the last few weeks. We still have to wear masks in Hong Kong. If you don't wear a mask in public, you will get fined 10,000 Hong Kong dollars, which is around 1,200 US dollars, which is not a small amount of money. And you notice the police particularly fine people more towards the end of the month if they realise their budget's a bit short. Sorry, I should say that. But that's one of the major issues, and so therefore coming to a country where people, very few wear masks, is a big change, and it's actually quite a shock at the beginning, because you get on the plane, everyone's wearing a mask, you get off the plane, nobody's wearing a mask. But apart from that issue, which is not insurmountable, it's something that you get used to. The only difficulty is trying to make legal submissions in court when you're behind a glass screen, the judge is behind a glass screen, and you're wearing a mask. It's a bit of a challenge, but we do the best we can, and some judges allow you to remove the mask. The most dangerous thing is when you're cross-examining a witness who wants to keep the mask on, because then you can't tell so easily if they're lying or not. But that's another story. But apart from that, I mean, that's what I think it would be. I'm very happy for anyone to ask any questions or feedback.
Thank you, Andrew. Thank you very much. Great takeaways from our international panel today. Again, the worst time you can establish a risk in your business is when the risk arises. So always have strategies in place before that risk potentially causes you problems. In disruptive markets also do remember that we have lots of positivity and businesses do flourish and grow in those times as well. So during the pandemic, PPE, face masks, sanitizing gel, hospital PPE, this business grew lucratively, and potentially governments were involved as well, and they made a huge amount of money. So despite the fact that to mitigate risk at the time, to help small businesses, they were giving grants and loans at the time, they did potentially find other avenues in which to generate revenue as well. And so in a crisis time, always remember that there are always opportunities as well. So it's not all negative, it's not all doom and gloom. And so if anyone has any questions for our panel today, please feel free to ask.
I have one comment regarding also COVID, as Andrew said that it is, at least for our company, it was some positive also elements, because within this time we managed to introduce rules for electronic signature. Before it was very complex, you needed to go physically sign or scan, and it was very, very difficult. And then with the time of COVID, then all managers, like more than 100 managers, we prepared rules, had electronic signature, and which is like specially issued by the state entity register center, and now it's without problem. I can sign all documents from everywhere I go, and it's like kind of positive. Also, seeing that it's positive that we introduced working rules remotely, and in terms of compensation, the question asked table, chair, payment for internet, something like that. Also, these rules were never existing, and nobody thought about them. So I think it's positive. Also, positive element. I think that it was this geopolitical situation forced us to speed revising supply chains. As before we bought oil from Russia, now we are buying from Aramco. And also our technological processes were smoothly reconsidered, because our factory was built 43 years ago, and it was designed for Russian oil. So our technicians and people who are responsible now are able to produce Arabian oil, because it was only choice before, and now it's with the speed, with the change of the geopolitical situation, this situation completely was kind of spirit, and now everything is okay. Also, as regards this one small correction Andrew made about this tax in Lithuania, this about 50% is only tax for employment and for salaries which are much higher than average. General legal entities tax is only 15%. It's not so bad.
Okay. So there's still chance for me.
Yeah, still chance to continue.
Thank you so much for listening, everyone. Unless you have anything to share, any experiences you've had, we would be happy to listen also. But other than that, we can have another chat during the networking break. Thank you so much for being a great audience. Give yourselves a round of applause.
On her behalf for so welcome, Daria, and from here I will hand it over to you to take it forward from here.
Hi everybody. As stated, I will focus on some topics related to M&A. Since we are in a litigation forum, I thought that it would be interesting to share some thoughts relating to information or on due diligence. I don't know if you, in your experience, which is the most breach wrapping warranties that you face or for which you see any litigation. Anyone would like to share some thoughts on this? Yes.
You want the microphone, otherwise the gentleman can't hear me.
We will record the microphone because we
Yeah,
have
yeah, that's right.
sound.
Yeah.
Yes.
Thank you. The usual ones that I've come across, I deal with dispute resolution, is where there is a retention of the consideration for a certain period of time to see whether any claims have arisen during that time, and if there are, then the money stays there until the claim has been determined. And depending on whether you're acting for the purchaser or the seller, if you're acting for the purchaser, I've often had clients, not that I would do anything unprofessional, to manufacture claims or to embellish claims to stop the money going on. and then you have a dispute to go to court as to whether the money should be released or not, which effectively is like a trial of the whole claim. And it usually ends up that parties settle because the amount that they spend on the legal fees is more than the amount in dispute. But that's where it's come across, and second of all, with tax warranties.
That's exactly, yes, thank you very much, it's very interesting, and based on some estimate by certain insurances, because they cover with policies, the most breached is actually, in my experience and based on the data that I have available, the tax matters, as is the most breached, like you said. And it's very interesting, the litigation issue that you said before. Thank you. So the tax matter, then the financial statement and accounting record. So everything is considered a number, let's say. And then also the litigation pending claims. What happens usually, how the parties try to protect themselves from breach of rep and warranties and try to avoid complexity in litigation. Of course, with the indemnification claim, clause, the breach of rep and warranties is always backed by a contractual clause provided for the indemnification of the non-breaching party. Usually the indemnification is limited both in terms of events, triggering the indemnity, and in terms of maximum amount of the indemnity. So it could be very, very different, and it's very important how a lawyer drafts an indemnification clause. And usually we always prefer that there is also a litigation lawyer assisting the client in addition to an M&A lawyer, in all the issues that could involve potential litigation. Another important thing to know, for example, in certain systems, like in Italian system, it's the reduction of the indemnity. The nature of the claim significantly varies depending on the wording as stated in the structure of the indemnification clause. Actually, the indemnification clause may determine or not the exact amount of the indemnification, or just can put the criteria for the indemnification. In the first case, when there is an amount, for example, in certain jurisdictions, be careful, like in Italy, because the court has the power, according to certain provision, to reduce the indemnity and consider this indemnity as a penalty clause, because a penalty clause could be reduced by the court, by the Italian court. Moreover, the exclusion of limitation of liability, which usually occur in this kind of provision, has certain limitations, of course. Because, for example, there is a most important aspect in Italian litigation, but I'm sure that there are other jurisdictions in which it is not possible to limit completely the liability. So in Italy, for example, it would not be possible to limit the liability when there is something committed with fraud or gross negligence. I don't know if there is any jurisdiction here in this room where it is possible to limit the liability completely. Anyone want to share? No, I think that always there are exclusion of gross negligence or at least fraud. Moreover, it is possible also to always to avoid to have difference in many litigations, of course, on the breach of rep and warranties. It is possible also, to insert in Italy and I guess in many other jurisdictions a sole exclusive remedy clause. Do you use usually this sole and exclusive remedy clause to limit, all the not so often. Of course, also in this case, you can lean in and say the only remedy is indemnification. So when you obtain indemnification, no other remedies is possible. But at the same time, there are limitations. For example, limitation for fraud or gross negligence. So if something is carried out with fraud or gross negligence, of course, this limitation could not apply. Then you have other action. And the same is for the nullity action, because the nullity action is an action that could be, of course, decided directly by the court, by the judge. Another issue to be taken into account carefully, so generally speaking, when we are dealing with wrapping warranties claims and any M&A claims, is how the clause is written, of course. So, for example, there is an interesting case before Italian courts relating to the breach of wrapping warranties. The Court of Milan was called to decide whether an indemnity was actually due following the alleged breach of the wrapping warranties about pending litigation. In particular, the wrapping warranties stated that were not, of course, were not any pending or threatening writing litigation against the target company. The buyer, after the closing, found out 44 different pending litigation and claimed the breach of the wrapping warranties. The defendant, the seller, maintained that the wrapping warranty should be interpreted as based on the literal wording, on what it was written, because the clause said that the wrapping warranties cover litigation against the target company. However, the court applied the principle of good faith in the interpretation of the contract, maintained that the interpretation provided by the defendant seller was too formalistic, because of course it should include all the pending litigation. So that's why it's important to ask questions, to imagine what could happen when there is a potential litigation in drafting this kind of written warrants. Because, for example, a clause that say not being party of litigation would avoid this risk, for example. This is one of the cases. Another and last aspect, because I know that then otherwise I will be out of time, is to take into account, like, as litigator, in a litigation perspective, that we do not have a disclosure discovery system in many civil law countries. So, of course, that's very important, of course, because the parties decide which documents could be produced, which documents could not be produced. So this is an element that should be took into account when we know that could be a litigation, and where will we litigate about this litigation, of course. And finally, another procedural aspect, very important in certain civil system, law system, and in particular in Italy, is the burden of proof. Because, and it is very strictly connected to discovery and disclosure. In particular, it is important under Italian law that when it comes to the non-performance of contractual obligation, the burden of proof is shifted on the breaching party, because the breaching party has to prove the exact fulfillment of the obligation. And so, and why the plaintiff has only, the claimant has only the burden to prove the existence of a valid contract. So this is very, very important, of course, linked to the discovery and disclosure issues. So this is just, to have an overview that, of course, the matter is pretty complex of the wrapping warranties. And of course, if someone of you want to share something about their jurisdiction, is more than welcome. I don't know any experience that you had.
I had experience with being an arbitrator in the claims of M&A on reps and warranties, and from my experience for the claimants, because we don't have any discovery proceedings, was very, very difficult in all cases to prove reps and warranties violation, because, for example, if due diligence was done, and later tax comes inspection and says that it's because of a violation of this and this was non-payment for tax and you need to pay, and then they go and say that it's a violation of rest and warranties, then our practice is that you do what you are buying and do due diligence. What is your experience?
It's pretty the same, my experience, because we have similar system at this point. You are from Lithuania, right? Exactly. So it's a civil law system without, discovery and disclosure system. yeah, it's the same. It's not easy. That's why we try to do an analysis, of potential litigation during, when we see that when there is, something like a clause or a rep where we notice that there is a lot of negotiation. Okay, we try, of course, to to focus on the documents, on these documents, and to try to see where there could be a litigation. But of course, it's very difficult because, because of course, you don't have, all the documents. You cannot request to the court. We have an order of exhibition that could be issued by the court, but there is a lot of discretionality. It's not very used under under our system, and there is not a real sanction for not, complying with the order of the judge. So I agree that it could be very complex. Yes.
So do we have more questions from Daria?
Presenting the buyer, you agree that the final installment is made after like 1 year, half a year, in order to really avoid possible disputes. Because in Lithuania we have such practice and it's quite common in SPA.
Yes, also, yeah. There are different mechanisms, but of course, this is one. This could be one solution. Money is always a solution. Payment is always a solution. Unfortunately or luckily, is in this way. Yes.
So do we have more questions from Daria? Or any kind of comment or opinion that you would want to add in the sessions for merger and acquisition?
Using this out, we are
So I see
using only,
there are
but
no
that's why
questions
I'm not
starting
checking
right now,
before
so
this
we will
camera
wrap it
output
up.
and we
So
are
thank you
checking.
so much, Daria, for joining us for the session.
Still
Thank
it
you
could
so much.
be
And
one.
with this, we will be moving to our session 3, which speaks about due diligence in business transactions. And our eminent panelists are Saloni Titreja, who is a regional legal and business conduct counsel at Gilead Sciences, Dubai. We have Shweta Priya, who is the legal counsel for Lloyd from India. Then we have Matthew Sinkit, who is the director from PSA Dubai. So I would request our panelists to please join us on the stage so we can start with the session 3 on due diligence in business transactions.
For sure.
Thank you so much, panelists. With this, I will hand over to our panelists to please take it forward from here.
Good morning, everybody. My name is Shweta. I am from India. I am from India. I work as an in-house legal head for Pullman, which is an EPC company. And few of you might know the company is under administrator, and we are going through a lot of due diligence for selling it as a going concern. So this topic is really close to my heart. So we'll start basically with a general idea of what due diligence is. It is a critical step in any business transaction, whether it is a merger, acquisition, or investment. This is basically a process in which we identify and verify the financials, the legal and operational aspect of a company before entering into any transaction. From a buyer's perspective, it is basically to know the seller much better, what has been superficially been shown, and to get into the documents and to assess if the transaction would be a beneficial one or not. However, recently in India, when the Insolvency and Bankruptcy Code was introduced in 2016, there was a process in which the companies are being sold to new entities, and in that process, administrator, basically known here, and a resolution professional or a liquidator known in India are being appointed, and due diligence is being done by that person as well to come to a reserve price of the company when they want to sell the company to a new business house. So when we do a due diligence for the administrator, we also get to, as a seller, we get to know the better value of the company. So So in an EPC company like ours, we have a lot of litigation claims. We have a lot of awards where executions are pending. However, the appeals are been going on. However, the first stage is in our favor, but the money has not been seen by the company. But that is a future prospect. So there are a lot of claims which increases the value of the company. So the prospective bidders also want to get into all those documentations. So that basically what are the types of due diligence and what are the process will be dealt by my colleague. So I'll just hand over it to her.
Thank you so much. Hi everyone, my name is Saloni Dudeja. I am an Indian qualified lawyer and I have a dual qualification from the US as well. I did my master's from Berkeley. I have been in-house lawyer for now 7 years and I have been a part of law firm for 9 years. So my claim to fame, at least in my own eyes, is that I have had experience on both sides of the fence. Currently, I am working in a pharma company called Gilead Sciences, and this topic is relevant irrespective whether you are a firm person, you are an in-house counsel, because it has so many layers to it. As my esteemed co-panelists explained about when you're selling it is very important for a seller, not only because most of the time we say, oh, it's very important for the buyer, but it is as important for the seller. So due diligence is relevant whether it's in mergers and acquisition, it is liquidation, but at the same time, it is very important on your daily basis also. When you get a distributor, for example, what if it's an exclusive distributor? Or you have a service provider which has a much longer, length of contract. So there are so many layers to due diligence. This is not an exhaustive list, but due diligence can be reputational. It can be transactional, financial, IT, IP. I don't know if I said contractual. Then it can also be competition or antitrust. Then it can be also related to environment, human resources. Anti-slavery is very relevant for most of us. We have in our contracts written anti-slavery and so many other relevance. And also, so the due diligence is, and its relevance, I cannot stress enough. In fact, it's a bedrock of not only an acquisition or a larger transaction like that, but it is also as important on your daily basis. So, and it's my favorite way of saying a good due diligence can lead to a good marriage or a miserable one. So it's up to us which kind of marriage we want to survive with. Another thing that I think, and I was discussing it with my co-panelists, is because we have so many layers, and sorry if I'm sounding like a parrot when I say layers again and again, but one thing that I have seen is a lot of times we have smaller teams doing due diligence, for example, for IT, somebody doing for IT, somebody doing for contractual, and they're not talking to each other. I think that has been something that has pained me for many, many years, and I'm not sure if I was the only one, but if others have had a similar experience. Because the essence of due diligence or why we are doing it is completely lost. If, I'm not sharing my report with her, or there cannot be a holistic view whether we should or we shouldn't do a certain transaction, get somebody onboarded, so on and so forth. And I think I've spoken enough, and I'll hand it over to you to talk and explain more about reputational due diligence.
Hello everyone, my name is Matthew Sinkes. I'm a director at Pacific Strategies and Assessments, PSA for short, not to be confused with our friends at ESA, the Arabic speakers out there. We're a due diligence and investigations firm. I'm based in Dubai. PSA has been active in the Middle East for about 5 years, but personally I've been in the region for about 10. And PSA was established about 20 years ago in East Asia by some former US government folks. And today we have 5 offices around the world. We're headquartered in Washington, D.C. but also offices here in Dubai, Shanghai, Hong Kong, and Manila. So when we talk about due diligence, I'm coming from more of the investigative fact-finding side, specializing in off-balance sheet risks and partnerships, pre-transaction and then investigations when things go wrong. So as one of the my esteemed co-panelists just mentioned, there's many types of due diligence. So there's the pre-transaction, like pre-IPO, pre-M&A, or simply partnerships with distributors. There's also compliance due diligence, which is a bit more programmatic and risk-based. So companies don't run afoul of UK Robbery Act or US FCPA regulations. And there's also increasingly a push towards ESG as part of the due diligence process. So I've got a brief presentation here that I'll just quickly run through. Just to discuss some of the challenges that are often encountered during the due diligence process. And I'll give 3 case examples that I was personally involved in, where we tried to come up with a solution to a problem that was identified. Just to quickly run through, we're active in almost every country around the world, especially the most opaque markets, the most high-risk jurisdictions. So just as a brief overview, we go through the common challenges, the 3 cases involving identifying the ultimate beneficial owners of an oil service company in Central Asia, outing a fraudster in the mining industry, and then exposing corruption within the life sciences sector. So some of the common challenges that are faced is identifying the ultimate beneficial owners of a company, especially in high-risk jurisdictions, opaque ones. Disclosure requirements vary by different countries, and then at times, depending on the jurisdiction, the person listed on the corporate record is not necessarily a real person behind the company, and that poses a challenge when you have the documentation, but there's good reason that you might be fronting for somebody or that there's something else going on here. And that goes along with if you obtain contradictory information from a counterparty, they fill out the questionnaire, something doesn't make sense, or you're running due diligence on the side of that, and then things don't match up, you have an issue that you have to deal with to resolve that. Sometimes you encounter a single source allegation, a major allegation of bribery, corruption, or fraud, but it could be just something as minor as an allegation from one person, a random person on social media, but it may nevertheless be something behind it. So how do you vet that information? How do you corroborate it to make sure that, is it just somebody, blabbing on social media, or was there something to this? There's also unknowingly engaging with a sanctioned individual entity. Not every person or entity will show up in the databases. There's other types of sanctions, so you really have to do more thorough. You can't just check the database, they check the box, everything is clear. Dealing with politically exposed persons and state-owned entities. It's not illegal to deal with politically exposed persons or state-owned entities, but it might change the way you deal with the counterparty. And lastly, getting an understanding of why somebody is selling. Is there something wrong that you don't know about? How do you uncover that to see if there's some underlying reason? So the first case, identifying the UBOs, the oil services company in Central Asia. Some of you might be familiar with, but business in Central Asia, especially after the fall of the Soviet Union, can be very opaque, very difficult. So in this particular case, the initial checks reveal a very complex ownership structure going across 3, 4, 5 jurisdictions and ultimately ending up in the British Virgin Islands. I'm sure a lot of you are familiar that shareholder information, access to it is very limited there, so oftentimes the due diligence process will stop. So in this case, pushed for more documentation. They were resisting, they were being evasive, and that drove a red flag. Now, the problem is that in this particular country, this company was the only game in town. It essentially had a monopoly, and so in order to do business there, you had to essentially deal with them. And there was really no way around it. So the way we approached this was we pulled about 15 years of corporate records, we saw the historical ownership changes, and it turned out that the initial shareholders in the beginning were within the same circle or orbit of a very politically connected, prominent businessman in the country, and that combined with some other source commentary in the industry, we were able to make we could call it a balance of probabilities assessment that this person was the likely beneficiary. So, no business transaction is without risk, but it helped the client develop a risk-based approach to making this decision on whether or not they wanted to proceed. Were they comfortable with the fact that they could be tying up with this particular person? The second case, outing a fraudster in the mining industry. In this case, a client was approached for a potential investment deal in Africa. Within the mining sector, the country ranked very poorly in the International Perceptions Corruption Index. But there were no immediate red flags, there were no immediate issues. So just a very routine due diligence on the person representing the company. But in this case, a local visit to the local courthouse to check for any litigation. The records were clean, nothing turned up. But then, to our surprise, a tip-off from the local legal clerk said, hey, you're not going to find anything on this person. He's very well connected. He's essentially scrubbed the records, so you're not going to find anything. But he has been the defendant in many fraud cases. So, we had to deal with, okay, this is a single source allegation. Is this true? And we looked into it further, and what turned out was that this was very known in the industry, just making a few phone calls that this is what this person does. He incorporates companies in the names of nominee shareholders who basically came to defraud investors. And on top of that, it also turned out that he was connected to some political figures within the country, which he did not disclose to the client beforehand. In the last case, exposing corruption within the life sciences. This also was a very routine due diligence, very low level. The due diligence process doesn't always have to be extensive. It doesn't have to be sort of cloak and dagger. Sometimes it's just, hey, call a former employee, ask how was their time working there. And in this case, what should have been a very routine due diligence check on a medical device and pharma distributor in the Middle East turned into a massive allegations of bribery, corruption, and fraud, that they were paying off hospitals, that the senior management was in on it, and of course these were very serious allegations, but again, it was single source. And we also had to wonder, is he biased? Did he have a dispute with his former employer? Like, why is this person telling us this? But it quickly turned out that, speaking to some other former employees, all of them had a similar take. And yes, it was true that this previous employer had mistreated their employees, so that was a motivation. But at the same time, they also backed it up with documentary evidence and emails and all of that. And so, what could have been sort of a disaster for the client was averted simply by making a phone call to someone who had worked there. And so these three examples, they just demonstrate how just doing a very basic check, sometimes that can protect your business just legally, reputationally, financially, and it doesn't always have to be necessarily an expensive endeavor. I mean, of course, the value of the transaction and other risk factors involved, you want to take that risk-based approach, but these were just three very simple cases that turned into something much bigger during the due diligence process. That is a brief overview of due diligence and some of the challenges.
Thank you so much. And this was, you mentioned about life sciences, and I must say life sciences is a favorite child of FCPA and UK Bribery Act. Every time you'll open FCPA page, you'll see at least 5 investigations, if not more, per page on life sciences, and I can speak that because I've been a part of life sciences for some time. In fact, an example that you mentioned, and somewhere it ties back to how relevant due diligence is. A lot of times I hear from business or other teams that, okay, or their apprehension about due diligence is if a report comes, it's a no-go. I think that's something, I would call it a myth, because it's not always a no-go. Sometimes it is, but sometimes it just gives you what is the depth of the water. It helps you do analysis of a risk. You may decide to go ahead with the transaction even if you get some red flags. Every red flag doesn't mean it's a stop. I think that's something we really need as lawyers or business conduct counsels, whatever our role is, whether firm or in-house, to explain that deeply to the business, because I believe that's one of their apprehension for due diligence. And an example I'll give is, the examples that my co-panelists mentioned about FCP investigations and so on and so forth. I was a part of one of the investigations. So Zimmer is a medical devices company. It acquired Biomet company, which is again a medical devices. It was under FCP investigation when Zimmer decided to acquire it. They knew about it, but they still decided for commercial reasons to go ahead. Due diligence, information about FCP investigation, still Zimmer decided to. So that goes back to my point that every red flag, every such investigation may or may not lead to a concluded transaction or maybe a no transaction. Second, what it helped Zimmer is that it could provision in case the FCP investigation continues for longer than it anticipated. It had provisioned for it from commercial perspective, financial perspective, resources perspective. So that really helped them have a proactive approach rather than reactive. So rather than getting business impaired, investigation has continued, etc., they were already ready for it. Another thing that I pointed out before is sometimes teams don't talk to each other. Another very good example at least I think it's a good example is, Dow Chemical Company acquired Union Carbide Corporation. Now, Union Carbide Corporation is one of the oldest chemical companies. It has brilliant IP rights, and that was one of the major reasons that Dow Chemicals acquired UCC. But I see there are a lot of Indians in the audience, and it's a world-renowned environmental litigation is Bhopal tragedy case. It's one of the largest in the world, and so when Dow Chemical acquired UCC, they acquired for IP reason, not giving as much importance about the litigation that UCC was going through, and it still continues. Despite 3.5 decades or more, and they acquired UCC. What happened with this acquisition is all the liabilities of UCC came to Dow Chemicals, and Dow Chemicals was already working in India. So not only they faced the wrath of acquiring UCC, but also their current business in India got impacted. So we have to see from acquisition not only what we are acquiring and how is it a good deal, bad deal, it is a good investment, bad investment, but how it can impact your current company and your current work as well. While lawyers, and I was a part of Dow Chemical Company, we did give submissions like it was a reverse merger, we did not take XYZ, but it takes time, especially in India, litigation takes time. So it's been 35 years or more, and Dow Chemical is still facing. And when DuPont and Dow Chemical merged, so liability continues. So and we all know it's always a big pocket theory. So it is, again, I think it goes back to teams need to talk to each other. Just merely having due diligence is not sufficient. It does not lead to no transaction, but a very good risk analysis much ahead of the time. So those were another point that comes to my head is also related to IP is, I'm not sure how many of us are aware about the litigation which was between Pernod Ricard and Bacardi for many years on Havana. And again, it's not specific to due diligence, but again, it comes back to the fact of, which is the primary reason we do diligence is risk analysis and whether it's worth it. So whether you do diligence or not, whether you do it formally between multiple teams, one team, but it is also very important to keep your ears close to the ground. A lot of times, you get the best information from your employees. They are not professionals who've been only who've been hired to do just due diligence. But since they are in the market, they can give you a lot of information. So again, as in-house or law firm, we should all strive to have a 360 degree rather than it piecemeal. So I think that was from my end. Does audience have anything to add? Their experiences, their heartaches related to due diligence, or questions for any one of us?
I was wondering in your example, it's state-owned entity. So, and ultimate beneficial and the owner, who is generally is, because in my situation they indicate, for example, Prime Minister of Poland is a beneficial owner. And for me, it's really, I said we cannot deliver just to banks, but banks said okay, we agree with it. So what is in your situation generally? What you meet in your practice?
Well, yeah, there's no sort of one-size-fits-all solution. I can think of one instance, also in the Middle East, where a new type of entity had been incorporated by the government, but it was a training facility, and there's no shareholders or ownership, and it's like, is it owned by the government? But there was no owners. So it puts you like in a gray area that it was hard to come up with that determination. Is the client dealing with a state-owned entity per se? So it's sort of in a gray area and kind of learning as you're going along, but still understanding that yes, there is some influence perhaps or control from the government side since it was established by that. So I think just knowing who you're dealing with, that is the most important part. A lot of times companies might go in blind and not realize, and then have to sort of walk it back years later, or face massive fines, or how are the payments going, or was this person really representing the state-owned company where they sort of made a little side business, and it's a constant challenge. It's ongoing, but yeah, you need to know exactly who you're dealing with, essentially.
Okay, thanks. It was a really informative session, but I'm just very curious to understand. A lot of you were mentioning about how you got a tip off from a lawyer, and you mentioned that you have to keep your ears to the ground and all of that. So how do you deal with a lot of confidential information or sensitive information that you have? Where does it form part of your report? Are these due diligence reports also applicable in courts in India or worldwide? How is that actually dealt with when you're looking at information which is really sensitive in nature?
Well, in some cases, you might work under attorney-client privilege. That is one way. Other times, you also, let's say you have information from human sources, but it could be very sensitive, or you're dealing with a jurisdiction where the rule of law is not very strong. There could be adverse impact on them and their well-being, or if they're from a lower socioeconomic background. So sometimes you also need to protect the identities of the sources. Maybe providing enough of a description to show that they're credible, but also obscure it enough to make sure that they don't run into any consequences. So yeah, that is a very tough issue. So it really depends as well.
And does that have that evidentiary value? Is it applicable? Like, for example, you're giving a brief description of somebody who's actually, you've taken information from somebody and you've just given a description, not the entire detail. So when I'm looking at the applicability, do the courts actually accept it to say, okay, this is genuine, or this is applicable, if I can use the word, or is it taken with a pinch of salt? How do we look at it? Or how does the court look at it?
Well, so as a non-lawyer, I don't want to give my sort of legal perspective on that.
So, in the due diligence report in India is not admissible as a document in court. However, the statements on which we are relying upon on the due diligence, that statement can be taken to the court as a separate document, not a part of the due diligence, and analysis of those statements and the person who would then state the same in front of court under oath can be taken as a document, as a documentary proof. The report will not be admissible.
And interestingly, what a part of your question is how much is too much sharing. I think that's a dilemma we face on a regular basis. And interestingly, both of us were discussing the same point. And that's why, which was with my comment earlier, sometimes we work in silos, so we are, one is not talking to the other. Client attorney privilege is not applicable in India, you know that. So it's while being a lawyer, it's very tough for us as Indian qualified lawyer. Now I work in the Middle East region. Where do we stand? It's always a pain and will be a pain. And at least for in-house, I can say for such instances and depending on the complexity and sensitivities, we do hire an external counsel because of the privilege aspect. The other thing is it's very important to share but not overshare, whether it's internally or externally. Another, if you're an in-house counsel, you need to determine whom you need to share your information. For example, director, because we have a lot of personal liability and there's a corporate liability. Then other thing is, if you see, and since we're talking more about due diligence, investigation, another thing that keeps coming to us as in-house lawyer is cooperate with the investigation, cooperate with external investigation, cooperate with SEC, DOJ, if it's an FCPA matter. Cooperation is good, but oversharing is never good. Intelligently share. Whether it's part of your due diligence, part of report, part of other thing. I have seen instances where people have overshared, which has backfired. And I have seen instances where, people have not shared or companies have not shared at all. I think creating that balance, having right professionals at the right time, proactive strategic decisions, things like that. I know I have overextended your question a bit, but that is very important. Due diligence is just the starting point, but what you do is something which is very important, and that again goes back to stages back to the risk analysis aspect that I mentioned.
I would like to thank you very much for this valuable discussion on this interesting topic. I have something in my mind regarding the revolution happening in the world in the field of the technology and transferring from the physical due diligence, whether in the acquisition or merger and acquisitions or due diligence on this matter, transferring into a remote due diligence. There are a lot of challenges on this matter, because in the physical due diligence, I had a kind of a transaction before in the past, but physically, looking about the data, transferring confidentiality matters, the IP ownership, regarding the regulatory issues, all of these things. But now there is a cyber security, there is a digitalization. So I think there is a kind of a challenges and risks around. I would be more than happy to hear about it from you.
So recently we have been, our company has been under due diligence, and this was all during the COVID period since 2020. And we actually had faced a lot of challenges because earlier due diligence was more of a physical thing. The consultants, the professional used to visit the company, we would provide them with the data, with the files, which was actually very sensitive. However, now what we practice in India is we create a data room, we provide security passwords to the consultants which can be used in specific IP addresses only which has been shared with us, and the IP team allows those IP addresses to access the data room. So that, and we also sign an NDA, non-disclosure agreement, before providing the access to those data rooms because the information is quite sensitive. And although I would want to agree with my colleague that we should share the reports internally, but we don't even share the reports with the bidders. What our due diligence report is for having a reserve price, we do not share it with the bidders who are independently doing a due diligence in India. So right now under the Insolvency and Bankruptcy Code, India has become a huge market for due diligence where the companies during the COVID have gone into liquidation or has gone into a resolution restructuring process. So a lot of firms have come up with a restructuring panel or a restructuring unit for specifically dealing with due diligences in India during the COVID time.
Another thing maybe I can add is, you raised such a great point about physical and now maybe through various modes like Zooms and so on and so forth. My experience is still work in progress, and because a lot of things that you do as part of due diligence is understanding people, their body language, your questions, and you cannot have 100% your laundry list of questions before you go, or 100% be prepared. At least I can't be. I'm sure there will be people who are. I can't be. And a lot of times you go there, and then once you see things, it's when you realize that okay, there is much more in things to it. Another example is when I was working in a law firm, my firm was hired, and I was part of the team to go and do due diligence just related to HR or labor practices in Maharashtra, that's a state in India. But when we went there, if it was just online, we would have just taken HR papers and all. But when we went there, and this is pre-COVID era, we saw it was much more than that. It was not only HR, then other things started coming in, regulatory compliances were not full there because regulatory compliances were not in tandem. There was corruption, bribery, very minimal amount, but SAP doesn't differentiate, so those were there. So this is how you open the Pandora's box when you do physical. But again, at least now we are maturing towards having a hybrid model, and I think I favor that much more than just doing online or just doing in person. I'm sure we all are very busy. It's not possible for us to go everywhere, every time. So I think hybrid model is something that we are looking with things that she mentioned, passcodes. NDAs have, the number of NDAs at least that I have seen in the past 2 years has exponentially expanded, and people have started taking it seriously. Honestly, a lot of times people were not taking it seriously. It was good to have, not must to have. So that's again something that is a COVID offspring, the importance of NDAs or any such related clauses or agreements.
And just to touch on your question, which I think is related, there is also a push towards technology and automation within the sort of due diligence compliance process, which I think is good in a jurisdiction, say like the United States, because there's just an unbelievable amount of information that is publicly accessible and that can sort of scrape data from all different sources. But it's a bit more challenging in, say, emerging markets or developing countries. They don't have those same databases. You can't just, scrape public domain information or what is available. You're not going to find anything, and it's like, oh, it's clean, it's fine, it's good to go. So talking about a hybrid model, I think that is also the way forward, especially in emerging markets where you do that sort of public domain research, but then at the same time you're also visiting, you're also engaging with them directly. And yeah, I think that's the best way to move forward, especially in opaque emerging markets.
Hello audience, do you have more questions from the panelists on due diligence? We'll be happy to take those questions. So if you have anything to add, your experiences, your parents, or any kind of thing, we'll be happy to take those. Alright, I see that none. So nevertheless, we will be happy to take those during the networking breaks or during the off session hours.
of networking hours. Now I would request our panelists to accept the memento on behalf of World Litigation Forum. So I would request Saloni Tuteja to please come forward and accept the memento on behalf of World Litigation Forum. Now I will request Shweta Priya to please come forward and accept the memento. Now I will request Nathu Sinkesh to please come forward and accept the memento on behalf of World Litigation Forum. Thank you so much, panelists. I'll also request everyone to please stand up and pose for the photograph with the mementos. So, thank you so much, panelists. Now we will be moving to our next session, which is session 4, which speaks about defending and managing cybersecurity threats, lesson learned from the recent data breaches. We have some amazing panelists and moderator who will be deliberating on this topic. The moderator is Ankush Mehta, who is a partner at Cyril Amachal Mangaldas, India. In the panelists we have is Tamir Zodi, who is a managing partner at Zodi Law Firm Egypt. We have Yak Chow Wee, who is a CEO at Gao Capital, Singapore. We have Simon Isker, who is a partner, head of insurance and cyber risk, BSAM at Dubai. So I would request our panelists to please come forward and join us on the stage for the session. Thank you so much, panelists and moderator, and I'll hand it over to Ankush Mehta to please take it forward from here.
Hi everyone, good morning again. We're speaking today on a very, very burning or hot topic, which is in cybercrime and cybersecurity. I think prevalent across all countries and all jurisdictions in the world. This topic affects us in our day-to-day lives as well. Even as lawyers, we have to advise on this very, very often. With this introduction, I have a stellar panel with me. With Mr. Temar Zodi, who is a managing partner of the Zodi Law Firm, based in Cairo, Egypt. And I have Chow Wei Yak, if I got that right, and who's from Singapore. She works in a hedge fund, who's going to give us the industry perspective. We're unfortunately missing one panelist, so I'll try and cover up as much as I can. Over to you. Thank you.
Hello, everybody. In the digital age, technology has revolutionized the modern world to communicate. The legal, no, it's okay. The legal and commercial implications are complex let's see the cybersecurity attacks in the last 10 years. Target. In December 2013, Target, the third largest US retail chain, was the victim of server hack attack in which 70 million customers had their personal information compromised, including their bank account details. As a result, the company reputation suffered a serious blow. This cyber attack cost about $1 billion. eBay. In May 2014, the American giant eBay was subjected to a cyber attack. The data of 140 million bank accounts of the customers breached. The stolen data was including names, email addresses, postal addresses, phone numbers, and even passwords. Sorry picture. In November 24 of the year of 2014, hackers attacked the computer system of Sony Picture in various locations, including its headquarters in Los Angeles. The stolen information, including films which became publicly available on the internet. The last one is Orange. The French mobile operator Orange suffered 2 cyber attacks within a few months in January and April 2014. Millions of customers' personal data were stolen, and these incidents cost Orange more than 24 million euros. And actually, 2018 was the worst of the cyber attacks year. There is 10 famous cyber attacks appeared in this year. The first one is Aadhaar was hacked and data was hacked and the data of 1.1 billion Indian citizens was leaked. The Marriott hotel chain was hacked and the data of 500 million customers was leaked. MyFitnessPal app was hacked and the data of 150 million accounts was leaked. Quora was hacked and 100 million users' data was leaked. MyHeritage was hacked and the DNA of more than 92 million users was hacked. Google Plus was hacked and the data of 52.5 million users was leaked. Chick was hacked and 40 million customers' data was leaked. Facebook was hacked and data of 29 million users was leaked. Ticketfly was hacked and 27 million users' data was leaked. The TimeHop application was hacked and the data of 21 million users was leaked. And the sectors most vulnerable to the cybercrime, all kinds of business sectors are exposed to the cybercrime, but the economic sector are most exposed to the cybercrime. It arranged according to the frequency of exposure to risk as follows. First one, the banking and financial service sector, then the healthcare sector, then insurance, then telecommunication infrastructure sector, then audit and accounting sectors, then aviation sector, then trade and retail sectors, then hotel sector, manufacturing sector, then architects, civil engineer and economist sector, then the construction sector, and finally food and beverage and tobacco industry sector. So the banking and financial sectors is the most threatened sector. The cyber risk in the financial sector was for theft or loss of data, data destructions, communication disruption, theft of monies, securities, funds, etc. And about the learned lessons, as the title of the session of the cybersecurity, we need the law is not enough to secure your data protection. So there's a legal protection by updating the laws in the countries and found learned and well-educated and trained judges and lawyers. And in my opinion, we need a special course for the information technology cases. The second thing is the technical protection. The technical protection is to depend on agencies who is certified to do their business in the huge companies. And the last thing is the awareness. Each company have the responsibility to ask or to train their employee to know about the data protection and how to deal with it. Thank you.
Thank you, Tamil. I just had a couple of thoughts before we move the mic. So I think when you mentioned about the areas which are vulnerable to cyber threats, such as banking or insurance or healthcare, any thoughts on how you have seen crypto being used as a medium of exchange of either ransom or blackmail? Any thoughts? Because we had an incident in India which I'll share, and maybe. So there was an unfortunate incident where some of the hackers had got into one of the large petrochemical companies' agency or contractor, and as a result of that, they said we can access the entire client database, the other sensitive information, and they demanded that the price of the blackmail be paid through the form of crypto. So these are things that are also gaining some traction. We don't know, for example, another matter, monies are coming into India but are leaving India in the form of crypto again. So I also like the point you made about training the law enforcement and the judges, because frankly that's where the buck has to stop, if I may put it. And their level of understanding has to be right up there, and it's only in terms of a reciprocal sharing that we can do with them in terms of information and learning. I think that will go a long way.
Hi, my name is Chao Wei, and I'm not a lawyer. I'm a hedge fund manager, and my original topic was on artificial intelligence. So I'm not as polished as my fellow panelists here on the subject, but I'm here to share a couple thoughts on that from my own experience. So being in a regulated industry, we have to have all these controls in place to prevent cybersecurity breaches. And for us, data was already low before this whole focus on cybersecurity. That's what we used to train on. But the thing is that we also use a lot of automation, and for example, in terms of operations, right? So like when someone puts in a subscription or redemption, money flows through the vendors to us, and then maybe back to the client when they redeem. So what has happened, it actually has happened to people we know personally. So who's responsible for any losses? If the process is supposed to be fairly automated for convenience, and so if let's say if me as the fund manager, if my email account got hacked, and then there was an instruction to the fund admin, and money was transferred to a bank account that does not belong to the client, right? So, I think initially regulators were not that aware of this problem, and they're like, no one's responsible for it, right? So it's an honest mistake, right? But now there are laws in place, certainly in Singapore, which I can only speak to because I'm from there, where they're saying that then the fund manager has to show that they have done all they can to protect such information. And so if this happens in Singapore now, I think it's very hard for the fund manager to escape, right? So let's say 10 million gets transferred out, and it's to an account that doesn't belong to the client upon subscription, then it's the fund manager's fault. So we get called in to give an opinion on whether what the fund manager has done is the standard. And you can't get away with it even if you say you have delegated the technology part, the IT part, to a third-party vendor. So which has happened recently in Singapore, where there was a company, ironically a tech firm, right? They hired another tech firm to manage the data. And then the tech firm, they put in a hashtag on one of the codes, and so it allowed a window for people to hack into the client information. So for a short period of time, right? And like 200 something customers wrote in to complain about it, right? So and what was the damage? Obviously, the tech firm actually got fined by the regulators as well, because like they're the ones who lost their clients' information, right? Then they sued the tech vendor, and the tech vendor is like, oh, I'm just a tech vendor, right? But no, because the tech vendor in their SOP, they're just supposed to provide accurate code, right, to give data, to set up the data structure, the database for the company. And so they were fined quite a lot of money. Like, I don't know, I can't remember, 100 million something? Oh, I can't, okay, sorry. It was an amount that I think might have even more than what they would pay for. So that's why it's really important to make sure that, when you're advising your clients, especially if they're financial institutions, it's important to tell them that they have to go above and beyond. Like, not just say, oh, I use Google Cloud and Google's a large company, therefore it's fine. No, I mean, I think that doesn't cut it anymore. And in terms of like lessons learned, let's say the client already has breached. What do you do, right? So, because I come in, depending on which side I come in, right? So either I try to minimize the damages or I try to maximize damages, right? So for me, I see like, okay, what has been done, right? So and then people will be like, oh yeah, no, I have all these measures in place. So I give a simple example. So one of my staff, my employees left. Okay, he tried to download all his information, all our information, to his personal device, right? So when he downloaded, immediately there was like bing, 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 everyone got notified. I got notified too. I was on the way to the bathroom and like bing, bing, bing. So he was not allowed to leave the building, and then we had to see him remove the data from his laptop before he was allowed out, and then he had to sign something that, if we found that there's anything illegal, blah, 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 he's legally liable, that sort of stuff. So if you wait till the very end, it doesn't matter. I mean, like the lawyers come in, they hire somebody, you get checked, and you're like, okay, this person did all these bad things. Doesn't matter, right? The information's lost already. And so me as the damages expert, like I'm gonna assign a really high number to that, right? Because you didn't do all that you can to prevent this, which would be quite unfortunate. That sort of stuff. And another simple example I'm going to give is my own phone, right? So I have a work phone, and I have a work profile on it, right? So I set it such that, and I lost my phone for the second time 2 months ago. So I thought I lost it. I found it afterwards, but it doesn't matter. So when I lose it, what do I do, right? Immediately, I tell my head of tech support, sorry, it's not tech support, it's the tech everything guy. So I said, I lost my phone again. I think I lost my phone, right? He's like, okay. So he goes in to wipe all the information from the work profile. I mean, of course, there's some stuff that I don't have on the work profile, like my dog's photo, but like that, I don't care, right? So that's the thing. Like, people must have a response, especially because there's like work from home now, or like bring your own device. You must be able to control the data. If not, again, I'm going to assign a very high value to damages. And then and the third example I'm going to give, and that's my final example, and it would be cybersecurity when you're actually on the case. We're just discussing this before this session, and a lot of cases are international, but then there was like COVID, and then you have to do by Zoom, right? And I had to submit my report. And in the older days, I think a lot of the judges or the head of the tribunal reading like paper stuff, right? But in this case, it had to be sent physically to him, to another country. I mean, you were given the option of the PDF, but I don't know, some people just don't read PDFs or cannot manage PDFs. And then I'm just like, and then he couldn't figure it out. And it took it delayed, there's a lot of delay, and I'm like, oh, I'm not sure where the information went to, because he said he just moved houses, you know, that sort of stuff. So I'm thinking like this whole cybersecurity thing also pertains to, you know, legal cases, where's my information going to? I don't know, like if something gets leaked, is it my fault? Probably not, right? But who knows, who's in charge of this? And we felt that maybe there needs to be a bit more awareness of anything cyber among maybe more elderly judges or elderly partners. Because they ask me weird questions, right? I once when I'm on the actual case, right? So we're doing this, and the other side, the senior partner, accused me of destroying information because I didn't keep the Zoom video. I'm like, no. You know what? It's a major threat for me, liability for me to keep all my Zoom videos. Yes, I record it, and then I keep it in case there's you know, whatever dispute, blah blah blah, and then delete it. Like I can permanently delete it. I don't just move it to the trash box, right? I delete it. And they're like, oh, you're destroying information. I'm like, you know, this lack of awareness, I feel. So that brings us back. I mean, that wraps up my part about lessons learned and what we should do and things like that. And yeah, open to questions afterwards. But for now, I'm going to pass the mic back.
Thank you for the lovely insights to panelists. I'm going to just talk about a little bit from an India perspective and hand it over, back to the audience. In India, Information Technology Act of 2000 really covers all measures and acts and cyber security related issues, which was incorporated in the year 2000. Of course, it's seen some amendments, but I think we can go for more. Where does the Information Technology Act apply? So if there is any offense or injury caused to any device in India, be it a mobile phone, a laptop, etc., by any person in India outside India, the Act will apply. That's number one. Couple of more things. One slightly anecdotal, but I'll just share that at the end. And we talked about cybercrime, we talked about the threats, but we have to also understand that technology is really, somewhere that's brought us together, kept us together, especially in lockdown, especially, where courts had moved away from physical form and we were all meeting online and Zoom hearings. At that point of time, we didn't, worry too much about data and security. It's now sort of an analysis that's happening that, oh my God, where's my data? Is it going to the wrong hands? Is there a threat? Is there a crime? How do you prevent? How do you protect? So all those things are getting very, very, sort of significant, talk now. And I know there are some, cyber insurances and other things that the market is offering, but from your own perspective, depends which organization you work with, or from a day-to-day perspective, this is what we hear from the law enforcement officials themselves. When they say change your password around every time, just change the pattern. For example, do a little dummy raid or a mock raid as far as your organization is concerned, just to check for any loopholes, etc. Last but not the least, as I said, anecdotal. How the cyber action, basically we talk about the information that is available for the public to see is one area of personal privacy or data protection. So we were involved in a matter in a very, some sense, like an indirect way, where we were asked to advise if a person has been acquitted or discharged of all his offences, right? We were sort of brainstorming on the concept of the right to be forgotten. Now, what does that mean? And why is it maybe important here? Is because today when a judgment gets passed or any orders get passed or there's anything, it's all over the world where anyone can access it, anyone can know. But if the person has been acquitted, there are laws in India, there are judgments in India which suggest that that data can be taken down. So this person will not have anything negative if the person has been acquitted or discharged. So I'll leave that with you. I'm happy to take any questions.
So in case anyone thinks that it's okay to not super manage the downside of when there's the security breach. So Singapore just had its first case where the Court of Appeals awarded damages for emotional distress suffered by a client when he found out that his information, so he's like a banking client, right? A private banking client, was being used by an ex-banker who has left. So it's not just actual damages in terms of things you can measure, like how many clients you lost, what the value of the trade, if you had done the trade or you had got out of the trade. It's also things like emotional damages, where if the client feels that he felt distressed because the financial institution did not respond adequately to tell him that I'm fixing it or I fixed it, then there's extra damages that you have to pay. So that's just leaving it as that.
Any questions, thoughts of the week? Yes, please.
Thank you very much for this kind of valuable discussion on this important topic. I think the information security and the cyber security is very important matter, because now the world is witnessing a kind of a revolution in the IT systems and developments. And I think the increase of the technology improvements and developments opens and means increase in the viability of the breach and having a cyber security threats and attacks. And we cannot prevent the fraud. However, we can manage and to mitigate it and eliminate it to the maximum and limits of the matter. But I'm going to talk about the banks and the financial institutions, because there are very important matters and considerations on this matter with regard to the confidentiality of the data of the customers, and also protecting the customers' rights as well. So this matter imposed for the banks and financial institutions is to provide a kind of implementing very tough and updated and safe IT systems and regulations. In addition to that, to adopt a kind of a more safe IT systems, and moreover to increase the awareness of the customers, because this is a very important point, because now the world is witnessing a dramatic changes and improvements, and the kind of the mind of the people is not that capable to follow this kind of very dramatic challenging developments on this matter. So that adopting updated systems and increasing the awareness, I think this is one of the two of the more important pillars that the banks and financial institutions should build the strategies to improve the awareness of the customer. Thank you.
I think I'll just add, I think you're quite right, sir, bang on. I'm sure I believe you come from Egypt yesterday.
Indeed.
Yes. So a lot of concerns and complications in India at least start at the very root of the KYC, or the know your customer information.
Yeah.
Very often it is taken so lightly that at the end of the day, when you are opening up the entire issue, you realize the KYC is not in place. So I just wanted your thoughts from your perspective. How important is the entire process, as far as you're concerned?
Yeah, and having a kind of a proper communication with the customers to increase the awareness, I think is very important on this stage. Thank you.
I just like to add that for funds, since I we're in Dubai, right, and there are a lot of funds here, you can't rely on like a financial institution and say like, okay, I've given the job to another financial institution to do the KYC. Even though legally we could, right? We could say we rely on somebody to do the KYC for us. So in order not to get into trouble if I have to pay damages, we actually do another layer of internal like KYC. We code it ourselves, we check with sanctions and stuff to make sure that it is in line with the outcome. And actually, I caught some of the previous panel when they talked about when everything's in English language, it's very easy to check. But when there are other languages involved, and so for me, I frequently have clients who are maybe they're Chinese, right? So there might be information on them in non-English. So I do an extra search to make sure that there's nothing out there in like, in Baidu or something. Okay, if it's on page 10, then I don't think anyone can say, hey, you missed it. If it's on page 1, the third line, then somebody's going to say, hey, you didn't do your job. And I can't say, hey, I passed it on to the bank to do the KYC, right? So I think there's a lot, like if let's say you're advising your clients and your clients say, I'm lying, whoever, and maybe it's like a global vendor, or custodian. So I'm a fake banker. I mean, I used to cover banks, insurance companies, financial institutions, and when I was at JP Morgan. So we have, in our contracts, we have lots of disclaimers. I'm not responsible, blah, 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 right? So that's why when people should be aware that if cybersecurity happens and you thought that you're covered because you use a world-class vendor, like no, you're not. And I think people should take steps to, and again, I'm repeating this, but then you have to go a little bit above and beyond to demonstrate that you really have tested. And the simple thing, like a lot of banks now have extra steps to prevent, right? But I test bank myself, right? I tell my private banker, I'm like, okay, give me my bank statement. I'm in Dubai, I'm in a hurry, right? Give it to me, right? Over WhatsApp. And my banker says you can't. He has to send me the secure email. And I'm like, dude, come on, you know me, right? And he's like, no, he can't. And he sends me the secure email. And I'm like, I can't remember the password. Like, it's so inconvenient, I can't open this. He's like, no, he'll send me like the password in a separate email to do that. So I think it helps to once in a while check. It's like checking the fire safety procedures and then document it in case something happens. And say, hey, I really tried my very best to make sure that they have the right procedures. Even though they told me they had the right procedures, I checked that they had the right procedures. And I think we're maybe being a hedge fund manager kind of super paranoid, but that's the world I think people are living in, and you don't want to be caught. Maybe you thought you already had it all covered for your client, and it's not. Yeah. Okay.
Completing to your words, yes, as we agreed, there is 3 points we have to do with not only with banking and the financial institutions, but we have,
because of loyalty to this war.
Yes. We need to have the legal protection and the technical protection, and the most important thing is the awareness, and to inform the clients, because your loyalty, inform your clients that the bank didn't ask you about the passwords, didn't ask you about the OTP numbers, didn't ask you about the confidential data of your cards or of your bank account.
You know very well our ads in the newspapers on the TV. Any other thoughts?
Coming back to the point that raised, sorry to interrupt, you raised a very important point with regard to the protecting the banks or the organization side, having a kind of acknowledgements and disclaimers of it. This is a very important point. However, in my opinion, I would prefer rather to protect the industry itself. It's not transferring the liability to other part or another, or to have a kind of a guilty person or a responsible person. I would rather prefer to increase the awareness in order to protect the industry itself, the organization and the clients as well. Thank you.
Of course, it's very difficult for the banks sometimes because they've done all they can. They have ads and all. They make life very inconvenient for me to protect everybody. But there's still people who fall for scams and that sort. And I've classmates who are in the government in Singapore, and they said like they found that they're actually just, no matter how many of these things they post out, the people who are supposed to read those things don't read those things. So the scams continue. So there are we're not talking about very high-tech espionage hacker type of people, right? So the scams are very basic. It's like someone calling you and say, hey, we know that you are using, your account has been compromised in China. or something like that, right? And then the person will be like, oh, I don't even have a bank account in China. But then they say, hey, but then we might arrest you. It sounds like who would fall for this? But a lot of people fall for this. And the banks try their very best, such that now, at least in Singapore, there's one bank actually had over a period of time last Christmas, or the previous Christmas, where a lot of people fell for this, right, despite the best efforts. The bank now has to set up an internal attack department to detect this possible transactions and to stop it. And so a lot of consumers say it's the bank's job to stop all this, but the banks are like, I can't stop everything. And there might be legit cases of people trying to transfer to their relatives or whatever, or So it's a very difficult situation. But then the banks, it's not just to I guess push responsibility, right? But they actually try very hard, I think. I'm not supporting the banks or whatever, but I'm just saying the banks are not in a situation where even if they have tried their best, they have to try harder. That's why I'm saying that they raised awareness, they gave me more boxes to check, right? And they now have to set up this department, right? So this particular bank even compensated some customers, which is slippery slope, right? Because it's not compensating, then people will be like, oh, then next time I can do it also. So it's hard to determine where your loss lies.
So I've just got one question, two points, if I may, about banks, and it's only because I haven't found any insurance companies here, so that I have to talk about banks. But first issue, you mentioned about sending a secure password by a separate email. But if the first email has been compromised, they're going to compromise the second one and find the password anyhow. So where's the logic of that? That's the first point. Second is, I think the difficulty I've had with banks in sending money is that the people you sometimes have to speak to the customer service operators. And I was trying to send money for school fees for my daughter to a university, and they still wouldn't accept that this university was a legitimate company or party to receive the money. So there doesn't seem to be any common sense used. If they have their rules, they're just followed slavishly without any discretion. And that's one of my complaints.
On the second point first, right? So I think now they've adopted this, I'm gonna make life miserable for everybody. Because I tried it myself. I sent money to myself. So Charlie Yak to Charlie Yak, right? And they're like, okay, this person might be a terrorist, blah, 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 blah. I'm like, okay, there's no logic. So I think it came about because it's so hard to tell who's legit and who's not. And there was one case where a client sent money to what they thought was a trust company, like a law firm, right? And it was a bit of change. Instead of law firm ABC, it's law firm ABC BVI or something. So there's a little bit of change, and the money went through. So now I think banks are not saying that it's university or law firm or trust firm, they will approve. So they have to do extra checks on that, and it's just inconvenient. Yeah. And to the first point, because the way I guess people access emails is per email, right? So they're saying that I don't want to send the password together with the first email, because then I can already use the password to access it. That's why they separate it out. So there is a technical reason why they split it out. Rather, because people don't go in and, they usually don't go into your email access. They just intercept, like emails by email.
Isn't it more logical to send it by different methods, such as SMS or something like that, rather than email?
For definitely they don't want to use like WhatsApp or whatever, right? So when I told them to send it by WhatsApp, they said no. But for them, I think email is for them is the most secure protocol. Because what else are they going to send to her, right?
Because it's encrypted. The email is encrypted.
It's encrypted, yes.
It's more safe than the SMS.
Yeah. Oh yeah, so now we we can talk less because Simon's here.
Hello everybody, I'm sorry I'm a bit late, but the timing's changed, so it's rather difficult for me to get here. I probably haven't understood what the panel has said, but I'm sort of coming from this on a different angle. I'm an reinsurance lawyer, and I'm sort of going to talk about really the insurance aspect of cyber coverage, really, essentially, and how important that is to mitigate any risk to one's business. We, my firm actually, PSA, we are the regional, what we call regional cyber responders for one of the largest reinsurance companies who work with a local ceding company, which is a local insurer. And we therefore have a response team based on this sort of policy coverage. So I don't know whether my friends have sort of spoken around about sort of legal frameworks, but you'll all be aware that we've had an influx of sort of data protection legislation of late, including sort of cyber laws as well. So it's pretty important really to sort of understand where we are going, probably in the direction very similar to Europe, GDPR coverage. We've had a new federal data protection law, which interestingly now sort of covers a notification obligation. And you'll probably be aware that there are obligations legally around the world where if there is a potential or a data breach, there's an obligation to notify. So my perspective really from this is sort of coming in from if you have clients, for example, you should be probably telling them that they should have some specialist coverage, and I would say that's a cyber policy. They may say, well, we have a cover on an indemnity policy somewhere else, but that's not probably the right, because that may not respond to a certain claim. And specifically, cyber coverage talks about first-party and third-party liability, so it's quite wide in what it covers. In this market, what we've seen is that most, even some of the larger corporates don't have the cover that's right, or they don't have any cover at all. And there is, cyber is sort of, or cyber breaches are brushed under the table to a large extent. We tend as a law firm to get involved essentially around when those breaches have happened. So it's really about sort of educating the market and using risk mitigation tools, and one of which is cyber coverage. So anyway, that's a bit about me. I'll hand the microphone back.
Thank you. Simon, we were just, we introduced ourselves, and Demet spoke about, the laws in Cairo, and Xiao spoke from the industry side in Singapore. So that's where, we just left some questions for the audience now. So there's
I have a question first.
Yeah.
So, I mean, we run a hedge fund, right? So we are always like, if you buy insurance, we buy a lot of insurance, D&O, we have all sorts of insurance, right? But when does the insurance firm actually pay out? Like, I've shared some examples of recent breaches where they're saying that, okay, it might be the fault of, let's say, the fund manager in not implementing as much controls as they could possibly have. And that's when I come in, because I'm like sort of the expert, right? So when does the insurance firm decide that, hey, it's something that you guys could have done possibly more? And when do you guys come in when, let's say there's a litigation, right? And obviously you don't want to be, the insurance firm doesn't want to be on the hook to pay out a gazillion dollars. When do they come in an investigation for valuation of damages?
Good question. The policy coverage will have an indemnity limit in any event, so there'll be an indemnity. The general rule about cyber, it doesn't cover any what we call infrastructure outages or third party. But generally, there'll be what we call warrants and covenants under the coverage that obligate the insured to put in certain systems in place. So you'll have to have certain security measures in place, standards to meet those coverages. Generally, they do cover most breaches because, as I said, it's what we call first party and third party liability breaches. So, for example, on a third party, you may compromise data subjects' personal data, And to that extent, at the moment, as I said, we're developing in this region with those type of claims. In Singapore, I believe, and in the West and Europe and the UK, we have very sort of substantive laws around the notification obligation. So the insurer will have a duty to generally sort of mitigate any loss and act as insurance lawyers say, act as a prudent uninsured. So there's a general duty there, but the detail will be in the policy terms, and generally coverage will respond to the extent that the insurer has followed all those provisions. So there'll be a number of sort of processes, what we call underwriting. The underwriters would go in and look at the business, for example, what type of business it is, and then they will have expert cyber people, I believe, possibly from the reinsurance market, because it's quite specialised, who will then look at that business and assess what the risks are. I mean, interestingly now, there are products pre-cyber breach in the market that allows someone to generally do a sort of data investigation on the current data sets that one has in the business and look at what potentially is exposed and what's not exposed. And that's also what we call another underwriting tool. So generally, if it's the right coverage, when I mentioned earlier that a client may think they have the right coverage, it might be wrapped up in a D&O policy, it might be a rider to, that's not necessarily the case because it may not respond to a certain incident. A bit more about the response and how that works. Generally, with a cyber coverage, you'll have a number of third parties written into that agreement that provides extra services. So, for example, a law firm, as we do, we are there on standby to sort of mitigate any of that risk to the insured and the insurer. So, for example, there could be local litigation here in terms of a breach, then you would step in. On the regulatory side, you would be obligated to make a notification to the regulator about the breach and potential breach, which is coming into this jurisdiction actually. And so that's where the lawyers come in. There would also be a PR marketing firm as well, who would be involved for the organisation to sort of step in and sort of do a damage limitation exercise as it were. So those are the sort of developments that we're sort of seeing in this market. As I said earlier, it's interesting because the current situation in the market is that there are many breaches here and there isn't a lot of specialist coverage. People tend to brush these breaches under the table, but they are important to a large extent because the exposure now is much more wider. We've had this new federal data protection law that's coming to our framework here in the UAE. It's generally drive into a GDPR model that way.
I have another question on crypto, which I think we're supposed to talk a little bit about, and because I've been asked to give my opinion on a number of crypto theft cases. So what happens when it's a combination of crypto and ransomware? Like let's say me and I have insurance coverage, let's say, right? And then someone says you have to give me $100 million or else I'm gonna destroy all your data set. In that case, does the insurance company pay the $100 million? Because I don't want to lose my data set, and to me it's like the MasterCard app, right? It's priceless.
So ransomware is covered, but as I said, there'll be an indemnity limit, so there'll be sub-limits under the policy as well. So ransomware will have a certain sub-limit under the coverage of the policy. But generally ransomware is covered, and also coverage loss arising from use of the system, for example, when it's down, that's also covered. So you'll see all those coverage, but there'll be limits on that coverage, so it's not open-ended as it were.
Do you guys want to talk about crypto, since I think there's quite a lot of crypto activity in Dubai, and yeah. No?
Not about crypto, but I think India at least has seen a very big boom in the fintech space, the financial technology space. And what's happening is, again, talking to the law enforcement and the white collar perspective, and probably cybercrime as well. So if money is coming through a payment gateway and into somebody's account, and if there is any fault or any alleged breach at any of lender's end, the customer's end, the payment gateway, or the bank's end. What is typically happening in the cases that we are seeing is that the police are freezing the bank account straight away and not realizing or not basically giving enough time to any of the stakeholders to explain that really where and what stage what is happening. It's then, we got to run to court, which is the magistrate's court, who unfreeze this, and at times it's their regular banking account, and it's not a very good sign if, it's been frozen for a month or more, it becomes difficult. So, but again, I think it goes back to their sort of mandate. I mean, they find something a little, borderline, they will freeze something, and at the same time, I think they're also learning along the way to understand these kind of complex transactions, because it's not something that they have grown up with or they have been taught. So so I think it's again, as I think somebody mentioned, it's a new phase. So hopefully we'll be right up there.
So the Singapore courts have actually, because I think there's more crypto activity there-ish. So Singapore the courts have found that they can force, you can have court injunction, you can Mareva injunction it, and you can actually force the platforms which say they have client confidentiality, blah blah blah, to freeze the accounts. So they don't tell you like it's Charlie Yak's account, for example, but you can track it back, right? Which wallet did activity come out from? Then you can go to like a Coinbase, for example, and say that hey, this wallet, when the person opened the wallet, there's information in it, you have to freeze that person. So that's kind of the things that people can do now. That in the past you have to subpoena the person, or you must know the person. But there are new crypto laws in Singapore where there's a cybersecurity breach, you got hacked. You don't need to know the person. So I'm not a lawyer, so I'm just saying what I know. The floor again, I think.
We're open for the floor, so if you have any questions, opinions, or any kind of comment that you want to tell, story that you would want to add in the panel, they're all welcome. So please, this is the second last session of the day to rather the 13th World Litigation Forum. So we request you to bring it on, your opinions, comments, or whatsoever you would like to add. So I think there are none. So with this, we will conclude the session 4 of the day 2. And I would request our eminent panelists to accept the memento on behalf of World Litigation Forum. So for this, I would request Ankush Mehta to please come forward and present the memento to our eminent panelist. So I would request Tamir Sodhi to please come forward and accept the memento on behalf of World Litigation Forum. Now I would request Yap Chow Wee to please come forward and accept the memento on behalf of World Litigation Forum. Now I would request Simon Isker to please come forward and accept the memento on behalf of World Litigation Forum. Now I would request Ankush Mehta to please come forward and accept the memento. Thank you for joining. Now I would request all the panelists to please pose for a small photograph with the mementos for the social media. Thank you so much, panelists and moderator, for such an amazing session. Thank you so much. I can see there's a little bit family lunchless rising in the room. So for this, we will move for a lunch break, and we will for an hour, and we will meet again at 2 p.m. for the rest of the sessions of the day. The lunch is in the Medley restaurant on the first floor. So I would request to move to the floor 1 to the Medley restaurant for the lunch networking break. Thank you so much, everyone, and meet you again at 2 p.m. for the rest sessions of the day. Thank you. I would request everyone to please seated. We will be starting with the last session of the day, that is session 5. So I request everyone to be kindly seated. And the people who are outside, I request them to please join us inside for the World Litigation Forum. So you do not miss out on the session 5 for World Litigation Forum. I'll borrow the mic from there for a while. Okay. May I borrow this for a while because the voice is again echoing. Hello everyone, a very good afternoon and welcome back to 13th World Litigation Forum, Day 2. Hello? I'll just check the audio video. There's some kind of disturbance.
Oh well.
It's your last day.
It was
So
last day, last session.
Last session.
Last session.
Should be a survivor's photograph.
Please check it.
3 mic 1. Hello.
It's okay now? Hello. So, hello, yes, welcome back to 13th World Litigation Forum, Day 2 of Session 5. I hope you all had interesting lunch networking break and you had amazing networking as well. With this, I will be resuming to the Session 5, which speaks about the compliance and risk in the digital age, cybersecurity, privacy, and data protection. And the moderator for the session is Damien Murphy, who is Executive Director, EMEA Advisory Lighthouse from United Kingdom. And we have 3 amazing panelists here with us. Niyati Oja, who is a Legal Counsel, HP India. We have Astrid Govardhan, Data Protection Officer from VFS Global, Dubai. Then we have Kesser Metwiya, who is a Managing Partner at Dr. Kesser H. Metwiya Law Firm, Saudi Arabia. So over to you, Damien. Please take it forward from here.
Thank you very much, everybody. So we have 4 lawyers up on stage, which is normally a recipe for disaster. But I think hopefully today we will entertain you and hopefully also inform you. So what I'm going to first of all do is, as is traditional, get the panelists to introduce themselves, and then I'll tell you a little bit about me, and then we'll start talking in more detail. And we're going to focus less on cybersecurity because the previous panel had a lot to do with cybersecurity, so we're going to focus more on compliance and in particular data privacy. One thing I would really encourage is we'd like to go out with a bang, so if you've got difficult questions, like the more difficult the better, and so please don't be afraid. The more interactive this is, the better it will be for everybody. So with that, I'd like my panelists to introduce themselves, and I'm going to start with you, Astrid. Could you tell everybody who you are and what you're doing?
Hi everyone. Good afternoon. My name is Astrid. I relocated to Dubai 1.5 years ago. I'm from Europe, lawyer, and worked primarily in the financial sector, focused on privacy laws in the European Union, and now in Dubai at VFS, where I'm the group DPO and ensure that VFS conducts its business in a compliant manner in all the jurisdictions we operate in. Thank you.
Thank you, Astrid. And then, Kazia, could you introduce yourself, please?
Yes, sure. I'm Kaiser Matawer. I'm a Saudi lawyer. I'm the managing partner of Dr. Kaiser Matawer Law Firm. I've been practicing for more than 18 years.
Hi, my name is Niyati Ocha. I'm the legal counsel for HP in India. I'm actually a IP lawyer. I've been an IP lawyer for literally almost all my life, and I've recently become the legal counsel here at HP. So I've actually had both sides of it, you know, from being a law firm bred lawyer to now being an in-house counsel. A part of my role in HP is to ensure that the company is fully compliant. Again, it's end-to-end. We do everything being in the legal team. So yeah, hopefully we'll have a good discussion today.
Thank you. And then just so you understand who I am, so I am a practicing barrister in the UK. So like if you don't know what a barrister is relative to a solicitor within the UK, that means that I have a grey wig and a black gown, and that's what really I've spent most of my career doing. But in recent times, I became e-discovery counsel at the big Swiss bank UBS, and now I am working for an American-based consultancy called Lighthouse, and that's who I'm representing today. So we have got a presentation. It's something that myself and Astrid put together before we managed to connect with our other panelists. So it's not a deliberate omission of their names, but we didn't even know they were going to be here. So forgive us for that. But I wanted to first of all ask Astrid to give us an overview of the main privacy regimes that we want to be covering today. And the slides will be happening behind her as she speaks. I'm just going to let her take it away. Astrid.
Thank you, Damien. So before I jump into the subject, I would like to tell a little bit about VFS, so you get a bit more understanding of my day-to-day work. Now, VFS is a company who has governments as a client. We help governments with their visa application processes. So we provide them with an IT solution in which data subject uploads all their personal data. They submit all kinds of data to us, even biometric data, sometimes financial data, criminal data, and we push them all through to the client government, who then take a decision whether the visa will be granted or not, and we push the reply back to the applicant. So that's basically what we do. A little bit of our vision and mission. So this is, we have a global presence. We have more than 60 client governments. We operate in more than 140 countries throughout the world. This is a footprint of our worldwide presence. And these are the governments we serve. Now, of course, if you talk about data privacy, one of the most important topic to cover is security, which lies at the heart of data protection. So VFS has a very high focus on its security framework. We have lots of ISO certifications in place to ensure that the biggest threat, which is the data breach, does not happen. So we take into account privacy by design default. We make sure that if we transfer data cross borders, so as you can imagine, because we work for all these governments throughout the world, we have to transfer a lot of data from one country to another country. And we just ensure that happens in a very secure way. We don't want that to be intercepted in between and prevent a data breach. So the weakest channel, the weakest chain the weakest part in the chain is, of course, the human error. So we put a lot of effort in training and awareness for security. People have to conduct all kinds of training to make sure they do not click on phishing emails, and they make sure that we secure the data as required by our client governments. And I want to take you through a few draft legal frameworks across the globe, because not every country, as you can see on this slide, has a data privacy law in place yet. Now the dark blue countries, they do have a privacy law in place. The light blue countries have a draft privacy law in place, and the gray countries does not have a privacy law in place yet. And as you can see, the map is only turning more and more blue, which is a good sign. That means that, you know, privacy is a topic that governments are focusing on. It is considered as something very important, but at the same time, because of all these different privacy laws which we have in different countries, it makes global organizations very difficult to comply to. I want to give you a brief background about developments with respect to privacy laws in the UAE. So we do have a federal decree law on personal data. And as you can see, the law covers lots of topics which are quite similar to the GDPR, not very different. So the extraterritorial effect is also part of it. So we're only waiting for the executive regulations, which should have been there already, but it's not there yet. I want to focus on the data subject rights. So data subjects, those, if I talk about data subject, then I refer to the individuals whose personal data is being processed. So these are natural persons. And in most legal frameworks with respect to data privacy, data subjects have certain rights, and we call them data subject rights. In short, DSARs. So similar to the GDPR, the UAE federal decree also have some data subject rights in it. A little bit about Saudi Arabia. I'm not going to talk much about it because Kesar will take you through it in more detail. But also in the Saudi privacy law, you will find data subject rights similar to the GDPR. And then China. China has a privacy law which is referred to as PIPL, which entered into force in November 2021. And also have data subject rights in it, which are similar to the GDPR. But apart from the privacy law, China has also introduced a data security law with a high focus on security, on how you process, how you actually implement security measures, but also if there's an outbound transfer of data across countries, you have to conduct security assessment, get clearance from CAC, Chinese authorities, in order for an organization to be able to transfer data actually outside of China. And with that, China has also introduced the data localization requirements, which enforces a data localization in China itself, which is quite a challenge for most global companies. And then India, I would like to zoom into a little bit. So India is one of those countries who does not have a data privacy law in place yet. There was a draft privacy bill, but that was withdrawn. And luckily, they have submitted a new bill on 18th of November 2022. And similar to GDPR, the draft privacy bill also contains data subject rights. And these are the right to information, right to correction and erasure of personal data, right of grievance redressal, and right to nominate, which is a little bit different than GDPR, because under the GDPR or China people, we don't have the right to nominate someone to exercise the DSARs. And the Privacy Act is also applicable to persons who have passed away, which is also different from the GDPR, because the GDPR is only applicable to natural persons who are alive. And then the United States, lots happening in the United States lately. So in the United States, we first started with California Privacy Act. There's no federal law yet in place in the United States. We do expect a federal law in the US, but it's not there yet. And in the meantime, California has come up with another set of rules which zooms into the rights of individuals, data subject rights. And Colorado and Virginia also came up with new privacy frameworks. And all of that will come into play as of this year. So lots happening in that area. I wanted to give you an overview of the data subject rights in the US. So if you look at Virginia, California, and the California Privacy Right Act and Colorado, you will see that the California Privacy Right Act has a little bit more than the other legal frameworks. It's quite similar to GDPR. There are some differences. For example, in the California Privacy Act, you will see there's a right to know if your personal data is sold. That is not under the GDPR. And in the California Privacy Right Act, you even have a right to know to whom it is sold. And to make the story complete, I've listed out the DSAs under GDPR and the UK GDPR, which are the right to be informed, right of access, right to rectification, right to be forgotten, right to restriction of processing, right to object, right to data portability, and right not to be subject to an automated decision-making, including profiling. Now, as you can imagine, all these rights that data subjects have, they can cause a lot of internal operational impact on companies operating worldwide. And, well, that can be sometimes an issue. And I would like to invite you, Damien, to take us through those issues.
We're here to talk about privacy and cybersecurity in the digital age and compliance. And one of the reasons why we're talking about subject rights requests is that complying with a subject rights request becomes on a daily basis essentially more complicated, because on a daily basis so much data is being generated. But before I explore subject rights requests, what I wanted to do, because I do think it's very important to look at the Saudi privacy position. So what I want to do first of all is get Kaiser to take us through in a bit more detail what's happening in Saudi. And then I want to speak to Nyati and kind of bring this to life in the sense that I want to hear what's in her in-tray when she's essentially dealing with all of these different things, and she's based in India, so she has a different perspective. So I'm going to start first of all with you, Kaiser, and I'm going to ask you, can you flesh out for us the situation in Saudi Arabia and give us your own take on that, please?
Sure. Can I? Good afternoon, everybody. The data protection law, or personal data protection law in Saudi Arabia, is really a hot topic right now. You know, it's important not only for Saudi people, even for non-Saudi people in Saudi Arabia. You know, it's very common for us, for example, to go to a store or even to go online and somebody is collecting our data. But we don't know what they're doing with our data. You know, are they selling our data? You know, modifying our data? We don't know what's going on. So, you know, for the Saudi government has enacted, you know, the personal data protection law in order to protect the rights of the data subject. Also to put some control, you know, because, you know, we have so many companies collecting data and we don't know what they're doing with our data. So we have this law which was enacted, the Personal Data Protection Law in 2021. It was supposed to come to force last year, but you know, it was deferred, you know, to this year, 2023, hopefully in March. And also there is an amendment of the law. It is not finalized yet, but you know, it should be finalized before March. So March is going to be the date of enforcing the data protection law in Saudi Arabia. Let's hope so. You know, that data protection law applies to private and public entities which process personal data in Saudi Arabia. Also, it applies to international companies which are processing data for data subjects in Saudi Arabia. So it is not okay, for example, for any international company like Google, for example, to collect data for Saudi subjects or even anybody in Saudi Arabia without being subject to this law. So this law is very important. We have so many international companies which are operating in Saudi Arabia or collecting data in Saudi Arabia. And also at the same time, it's very important for them. Even in my law firm, right now, as you told you, this is a hot topic. We've been receiving requests from international companies regarding, the boundaries of the law and what's going to happen after applying the law. It's very important. It's very serious because even, the penalties under the law are very serious. So that's why, international companies are very interested in knowing, what's going on in Saudi Arabia right now. So the law applies to genetic data. I'm going to explain this. Health data, credit data, as well as sensitive data. Also, for entities which are going to collect data or personal data in Saudi Arabia, they have to be registered with the competent authority. So it's not like, you just collect data as a company without registering in Saudi Arabia, without registering with the competent authority. Why? Because the competent authority wants to know what you are doing exactly with the data. Do you have enough protection or not? And so forth and so on. So, personal data, what does it mean, personal data? Personal data, any data which identify you, okay? It could be, your ID number, your name, your photo, and so forth and so on. Sensitive data, any data which is, related to your racial, your religion, your political beliefs, all of them are considered as sensitive data. Credit data, it's your ability to obtain loans and, pay your debts. Genetic data, any data related to your genes, for example, any samples which is taken from you, such as DNA, for example. Health data, any data related to your health, your mental health, your physical health, all of this data are considered as health data. Now, we have, under the law, a processor and controller. Processor who's collecting your data on behalf of the controller, and the controller who's, getting the data. Okay, the controller can be in Saudi or outside Saudi Arabia. That's why the law applies to any entity or any controller or processor inside or outside Saudi Arabia. Because, it's very common in Saudi Arabia. And it's very common, by the way, in any country. For example, you go to a store, you want to purchase shoes, for example, all of a sudden you start getting advertisements regarding, other stores, for selling shoes. So how did they find out about you? They found out about you because they've been collecting your data. So they know exactly, for example, when you purchase a ticket, a flight ticket from Saudi Arabia to Dubai, for example, all of a sudden you receive, advertisements from hotels in Dubai. How did they find out that, I'm going to travel to Dubai? Your data was sold. So it's very important. It's very scary that, sometimes, you get phone calls collecting your data. Sometimes they find out many things about you, which sometimes scares you. How did they find out about this? Because they have been collecting your data. So your data is very important. So the rights, this is now the data subjects' rights. It's very important to know your rights. I want to know what's going to happen to my data. So the first thing is that they need to inform you. Anybody who's collecting your data, you need to be informed regarding the purpose of collecting your data. I want to know why you are collecting my data, why you are calling me right now, asking me, to provide you with my ID number. What's the purpose? So you have the right. the good thing about yes, I'm gonna stop. I'm gonna continue, but I'm gonna stop it. The good thing about having a law, even if it is not enforced, at least you know your rights. You know, it's before the law, everybody was oblivious of his or her rights. Okay, somebody calls me asking for some data. Okay, here you are. You know, take the data. But now you know your rights. No, stop here, please. I need to know the purpose of collecting my data. First, you have also the right to complain to the authorities regarding, you know, collecting your data. Also, you have the right to ask for the distraction of your data. You know, okay, you collected my data for something which I approved, but now it does no longer exist. I want you to destroy my data. You have the right to do this. Also, you have the right to ask, you know, for transferring your data to another controller. You're not happy with this controller. You want your data to be transferred to another controller. You have the right to do this. The right of correcting your data. Sometimes, you know, if your data is not correct or not complete, for example, you have the right to correct your data. Also, you have the right, you know, to get your data in the format you want it. Also, you have the right to access your data. Your data with the controller, for example, and you want, you know, to have access to this data. You want to see it. You want to review it. You want to do whatever you want with it. Also, you have the right to ask, you know, if your data is going to be in Saudi only or outside Saudi Arabia, because, you know, as I told you before that, you know, we have so many international companies operating in Saudi Arabia, such as, you know, Google, Amazon, and others. And of course, you know, many of them, they have their, you know, center outside Saudi Arabia. So the data or your data is going to be transferred anyway. So you have the right, you know, to be informed if your data is going to be in Saudi, if it's going to stay in Saudi Arabia, or it's going to be transferred. Then, you know, we need also to know the obligations of the controllers. First, you know, they need to get your consent. Sometimes, you know, your data is with the controller, and, you know, without knowing, you know, as I told you, all of a sudden, you know, you receive advertisements and all that, and, you know, even, you know, for cautious people, you know, I know that, you know, there are so many people who are very cautious with respect to giving their information, giving their data, and, you know, despite all that, you know, their information is out. So, you know, they need, you know, the consent. If you say, no, I don't want you, you know, to send me any advertisement, for example, or no, I'm not going to provide you with any data, you have the right, of course, to do this. Collect the data from you. You know, they cannot just go around, you know, try to grab bits and pieces from some other data collectors and just, you know, have a profile of you, for example. So they need, you know, to collect the data from you. So you have the right, you know, to give the data you want, and you can just say, oh, sorry, I'm not going to give you this. Or, for example, are you married? This is not your business. I'm not going to tell you if I'm married or not. So also select a processor that guarantees the compliance with the law, because we know that, you know, some processors, they are not in compliance, so you have the right, you know, to select. Also, they have to have a robust privacy policy. You need to know the privacy policy. You need to read it. You need to make sure they have a good one, because that is going to protect your rights. Also, take sufficient steps to ensure the accuracy and the completeness of your data. So they need to have accurate data of you, just not, you know, incomplete data, for example, which is not correct. Also, they need to register with the authority or the competent authority. As I told you that, you know, the competent authority is very important here to be registered with, just to make sure that, you know, they have all these requirements in order. Must implement also a safeguard to guarantee that, that there is no leakage of the information. They have a robust system. So, there is, no hacking, for example, in order to steal data. And it has happened, as you know, that, with many companies, that all of a sudden you hear that, around, 200,000, credit card numbers are out there because of the leakage. Notify the country of any correction or completion and updating regarding their personal data with respect to transferring it. Now, I've talked about the rights and obligations. Now, I think the time to talk about the penalties. The penalties for disclosing data to gain benefits or cause harm, the penalty is very severe. It's imprisonment up to 2 years and a fine up to 3 million Saudi riyals, which is around $800,000. Transferring or disclosing data to entities outside Saudi Arabia, we're talking about 1 year imprisonment plus a fine up to 1 million Saudi riyals. And of course, for any other uncriminal violation, it can start with a warning and ending with a fine up to 5 million Saudi riyals, which is around $1.5 million. And it could be doubled. Private claims, you have also the right, to file a lawsuit for private claims, to request for compensation for material or moral damages. Additional remedies that, the publication, of course, if there is any violation, in addition to all the penalties, also, the name of the violator will be published in the newspapers in Saudi Arabia. So that's all for me. I hope, I just gave you some information regarding, the new law in Saudi Arabia. And hopefully, that this new law will be enforced in March. And of course, next year, maybe if you are here, we're going to update you regarding the new law in Saudi Arabia. Thank you very much.
Thank you. You got a clap for that. That's really good.
Hopefully I worked you up. That's the most important thing.
Niati, I wanted to turn to you, but I did have one question for you, Kais, before we move on, which is the enforceability. Your view is, because you said at the moment you know what your rights are, but they're not enforceable. From your point of view, how sure are we as to when that date will be that it becomes enforceable?
As I mentioned, that hopefully this March, it's going to be the enforcement date, and I think as I told you, the law was enacted in 2021, and it was supposed to be enforced last year, and I think the reason for not enforcing it because the competent authority was not ready yet. So the competent authority in Saudi Arabia wants to make sure that
once the law is enforced, it means that actions will be taken against any violators. Thank you.
Okay.
Thank you. Now, so Saudi's moving like relatively quickly, but if you were paying attention earlier on in relation to India, you'd have seen that India started to move and then it stopped, and then via a tweet, which is really cool, it announced it's getting back moving again. I wanted to turn to you, Niati, because you have, I guess, the very difficult job of trying to stay and make sure that your company is compliant, but at the same time you haven't actually got a data privacy framework to be compliant against. So can you just explore for us in a bit more detail, like how does that cause you problems? Is that difficult, or is it actually really easy when there's nothing in place?
Thanks, Damian. I think the first thing I would say is I'm frustrated, okay? So you were being really hopeful with your timelines and everything, and I somehow, I was trying and wanting to be hopeful, but not really. So when the previous bill was withdrawn and the new bill was in the pipeline, I think a lot of us and all my Indian colleagues will also agree that all of us were very hopeful that this is going to actually cover all those things that the previous bill was missing, right? Obviously, it's still under discussion if it's a sufficient bill. Are we wanting more? Are we wanting less? All that is still under discussion. But knowing that we don't have a really strict framework, like we do have a privacy law, we have what you can say your information technology law, we have a broad framework, but the main bill is still just a bill, it's just a draft, right? So that became a little frustrating for me personally as well. And as an organization, you then start wondering as to what are you supposed to do to, one, stay compliant, because what are you supposed to stay compliant with is the biggest question, and then how do you do it, right? So a few insights that I can give from my perspective is to understand what is the organization's requirement, okay? As a business organization, we are more conservative when we look at it from the perspective of an infringer, or I'm just going to call it cyber risk, okay? Because all of that is covered under that, your data security, your data privacy, your cyber security, all of that. So all these attackers of a cyber risk have it easy, you know, the legal implication is lesser, they do not have all those checks and balances that a business organization generally does have, and all of that. So you are actually competing with somebody who does not have a threshold, vis-a-vis you being a business organization that has a very strict threshold. So it's very important to understand how do you structure yourself over here. What I think works, again, this is trial and tested, but what I think really works is to have a very strong internal framework, a governance structure within your organization to handle this kind of a situation. I personally believe cyber risks cannot be avoided. You just cannot avoid a cyber risk. Somebody in the previous forum was obviously talking about the numbers, right? There was Facebook, there was Google, there was Twitter, there was Meta, everything. So you can't really avoid a cyber risk is what I would say. But yes, of course, as an organization, it becomes very important that you manage the cyber risk very well, right? So having a strong internal framework is, I think, very important for all organizations, and that's what everybody should go towards. To create this framework, I'm just going to be really short, and I'm just going to touch upon a few important aspects that you should keep in mind while creating this kind of a framework. Every organization first should understand and identify the kind of data they deal with. Okay, every data has to be looked at with a lens of what your industry actually is involved in. So, for example, a retail store, their data, their oil is customer data, right? For them, that's their most sacred data. Vis-a-vis, when I look at, for example, an oil and gas company, maybe customer data really doesn't work for them. Rather, their exploration sites, what is going to be their next exploration idea, all of that would be more important. So one thing is to first identify the kind of data that your organization deals with, understand how that is collected and how that is stored. That, I think, is the primary requirement of creating a framework. Okay. Second is stop looking at a cyber risk or a data privacy incident or anything of those sorts as just another operational risk, you know. Okay, we have so many issues, supply chain happened, this happened, that happened, the orders did not get loaded, all of that, you know. It's not just an operational risk that actually just affects the daily operation of your company, right? It's a reputational risk. It has far more repercussions than just another business risk. So identifying the data, classifying it as a substantial risk is very important. And this tone has to be set right on the top. I think the business has to understand the directors of the company, the management of the company have to set that tone to say that for us, our cyber risk is something which is very important, something that we do not compromise with, that we take, with a lot of seriousness and importance. It's very important that way. Setting up, you've identified your data, you've identified your business, you've identified what's required, you have an IT team, right? But the responsibility of a cyber risk is just not on your IT team. It has to be a cross-functional, cross-departmental activity. You cannot just think that, okay, there's a cyber risk incident, I've informed my IT team about it, my headache is gone. That's just not good from a framework perspective, because at the end of the day, the business does suffer a lot more, like I mentioned, a lot more than just an operational risk. Right? So a cross-functional team, I believe, is very important. Your CIOs, your CFOs, your CLOs, and your CEOs, members of the audit team, there should be like a war room team that should always be available that takes care of these kind of cyber risks incidents. That's very important. Another very important aspect that we generally fail to consider is people. People form the basis of the organization, and while I personally do respect CDAs and NDAs, etc., but practically I've always noticed that it's really never followed, So we're sitting over a cup of coffee and we are discussing high-level deals, which should technically be covered under CDA. And I'm not saying this is from the legal perspective, but business, right? I'm in an IT company. I have 2 people trying to sell a laptop to a third person. They want to sell, right? And they can use any information they want to sell, because at the end of the day, the box has to be sold. So, making sure that your people are aware of what a cyber risk could be, what the repercussions of the cyber risk could be, is very important. Like within our organization, it's very interesting. The first time it happened and I actually failed that test, they had sent us a link and they said, so they'd asked us to click it, they said, and it was a lovely email, and it was something which spoke about some activity that was being done by the organization. And in all my excitement, and I'm a privacy person, like I ensure that I read my emails, I look at the confidential part of it, all of that. In my excitement of this activity which was coming out, I clicked that link. And it was really funny because this huge red color alert had come to me and said, this is a phishing link, you're not supposed to be clicking it, why did you do it? And they asked me to do my cybersecurity assessment all over again, right? So people, I'm not saying intentionally, but unintentionally also end up being in this whole place where, the red, the whole, you have been a victim of a phishing attack, it just comes and hits you on your face. And I was pretty new to my organization that time, and I was just looking and I was like, I just hope this doesn't affect my appraisal, I just hope this doesn't do anything to my promotion, right? So that really works there. So ensuring that that people are well aware. And one thing I've realized never works are these boring trainings, I have sat through so many of them, and eventually I think we did tell our organization that we are bored of your trainings. So for some reason, our next cybersecurity training came with a Shin-chan logo, and we had to actually work towards Shin-chan not being a victim of a phishing attack, right? That was how funny they tried to make it. So that's how they did. I think it worked because I still remember it. I still remember the training, what I did. It was, I think, 2 years back, and just that interactive training really helped us, So it's very important that organizations do ensure that their people, they've set the tone at the top, the management is aware, but your daily business, your daily people operating have to be aware of what cyber risks are and to manage it. Especially when we don't have such a strict law in place where we cannot just clearly tell them that, listen, this is not allowed, right? We are still in that, like, light blue, like you mentioned, we're still light blue. Though we're not gray, we're still light blue. But these small techniques really go a long way to help an organization understand that you are at a situation where you don't have everything figured out for you, but you're still trying to figure out. So I'd just like to put it in words, in 3 simple words so that everybody understands. You identify, you prioritize, and you then resolve. That's how you're supposed to do. Just one last portion that I'd like to talk about is resolving the risk issue. Now, organizations have that risk appetite. They know that they're supposed to be taking this kind of risks. They know that this is going to be helpful for them or not helpful for them. the two ways I feel is relevant to help resolving risk is one, to mitigate it, to stop, to ensure that it stops. That's it. You know, it does not further damage the risk, the cyber risk that has already happened. And the second is to restore. How much can you actually recover or restore from the data that has been lost? Reputation is just something which is completely different, but at the end of the day, you're dealing with data, right? So you have to ensure that whatever you've lost, you should be in a position to recover it. So if your organization does not have that internal capabilities, it is always better to engage independent advisors, make sure that they are able to, or develop an in-house team. I think developing it is good, but if you still, there are cost restraints with everything. So if it's still difficult to develop the team internally, it's always better to hire external advisors who can actually set up this framework for you on your organization and ensure that like I said, you cannot avoid it, but at least you can manage it. So I think I will stop with that.
Thank you, Niyati. I mean, I think I got the reverse in terms of problems about sort of spam and phishing, because I would just send these emails that were irritating and annoying to the line and report them, and then they sort of came to me and said, like, you can't just send emails from HR and IT back to the phishing line because it's just normal internal emails. So I got into a bit of reverse trouble on that. Now, Astrid, if Niyati's just given us some insight into what's in her in tray in an environment where the data protection framework isn't solid as yet. You showed us a slide earlier on where you could see the range of data privacy laws that affect your company. What's in your in tray in terms of staying compliant faced with just that huge array? I mean, where do you start when you're faced with that number of different privacy frameworks?
So the approach that we took within VFS is that we use the GDPR as the golden standard. Now, every time when new law comes up in a certain jurisdiction, we make a gap assessment against the GDPR. And we look where there are more stringent rules in place, and we always apply the most secure and most stringent level of protection to the individuals. So that is the way we try to stay compliant. So, for example, in India, where we don't have a privacy bill yet, we would apply the GDPR requirements as a standard, just to make sure that at least we have within the organization a certain base level of protection that we adhere to in all our practices. That is the only way we can actually kind of manage it. Because
Does
you
that
can
not cause some sort of frustration from people saying, well, hold on a minute, we're spending, like, we've adopted this gold standard and we're therefore having to invest more than we might otherwise have invested? Does that not cause, do you not get sort of pushback along those lines?
Actually, well, within VFS, not. And I think if you get pushback, it's very important, because I've been working in organizations where I got much more pushback. I think the trick is to be able to explain to the higher management that privacy is not a tick-the-box thing. You know, we just have to comply with the law. And I say that as a lawyer, yeah. I think it should be something that you as a company value the most, and it becomes one of your key selling points. So if you look at Apple, for example, sorry, I'm an Apple fan. So, well, like I said, in the US, we don't have a Federal Privacy Act. Nevertheless, Apple has used privacy as one of their key selling points without any legal framework, and I think that should be the way forward. You know, you shouldn't, as an organization, when you deal with personal information from your clients, the least what you can do is to live up that expectations that clients have about your organization, how you treat their personal data. And there shouldn't be a law there telling you that you have to do that.
Okay. And so how often do you find that the GDPR is exceeded by, when you compare it against something? Because in my mind, and it's probably a Eurocentric point of view, I think to myself, well, the GDPR kind of is the gold standard, but when you're doing that comparison, how often do you find, or can you give us an example where it's like, well, GDPR is there, but actually this other legislation is above that, there's more to it, or have you not come across that as yet?
Not so. I do think the California legal framework goes a little bit further than the GDPR requirements. Especially, they have this different legal framework with respect to data subject rights, which is only about data subject rights, with a little bit more than GDPR. Yes. Okay. So in that case, we would then assess the organization in US. We would make the gap assessment against the GDPR, and we would implement those extra requirements that are there.
Thank you. Kaiser, we didn't discuss this in advance, so I apologize. But I want you to look in your crystal ball. And one of the things that I have found interesting as we've watched the GDPR emerge over time is when are those big decisions going to come along that will be kind of the ones that will be such a scaring factor that will move companies. And in many ways, if you look at the GDPR, you'll find there's a lot of decisions have taken place about data breach, right? A lot of decisions have taken place about lack of consent. That's the two big GDPR fine areas. But if you're focused, as I often am in relation to data management, information governance, that side of things, then it's actually quite hard to find significant fines around that you can put in front of a company and say, look, if you don't sort your data out, like if you don't minimize your data, if you don't reduce the amount of data you're retaining, then you'll be in trouble, right? So it hasn't, in my view, as yet in the GDPR, there is not that sort of focus of regulators in terms of the fines that you can show companies. Looking into your crystal ball, do you think that under the Saudi personal information protection law, we'll see enforcement quite quickly after, like, let's say March is the time when it becomes enforceable? Or do you think that, again, it'll be more like the GDPR where it'll take years for it to happen? Can you give us any insight on that?
Yeah, sure. I think, after March, I think, that the enforcement will be there. Why? Because right now, we have the 2030 vision in Saudi Arabia, which is very important. Actually, it's very important right now for the government, to diversify its income sources, and of course, one of which is that, attracting foreign investments in Saudi Arabia. So in order to do this, you have to have, robust laws in order to attract. So as long as you have companies which are relaxed with respect to the data protection, you deal with companies that, you don't know what they are going to do with your data information, or what they're going to do with it. Are they going to sell your data? That is not gonna help, the foreign investors also to come to Saudi Arabia. So I think, that the Saudi authorities right now are keen, to push companies in order to comply with the law. And I think, the enforcement will be after March, because as I told you, last year it was, the year for the enforcement of the law, but, it was deferred to this year because, the competent authority is trying to make sure that, once the law is enforced, they can go after the violators. And believe me, Saudi Arabia has done a great job, in reforming, its laws and regulations in order, not only to attract foreign investors, but also, to achieve the vision of 2030.
Thank you. I appreciate we haven't as yet had any questions from the audience. But yes, sure.
So when you talk about competent authority, would that competent authority have exclusive jurisdiction, or it will still allow you to seek remedy from a civil court or from the law enforcement?
Okay.
So just to recap the question in case anyone at the back of the room didn't pick that up. The question is, if there's a competent authority, essentially we're asking for comment on the extent of its jurisdiction within the Saudi law.
Yes. Of course, the competent authority has only jurisdiction in Saudi. However, yet to come, I think, there are going to be many treaties, international treaties in this regard. as we have international treaties in other areas as well. But for the data protection law, it's very new law. It's not only in Saudi Arabia; it's a new law in many other countries. So I think we're going to see more and more international treaties regarding the data protection, because right now we live in a small world. Many companies are extraterritorial. They operate in different countries, and unfortunately, for some companies, even their privacy policy, for example, it relaxes in some countries, while for other countries which they have very robust law, they have very high standard. So that's why I think in the future we are going to find more and more treaties regarding data protection.
Thanks. So, sorry, just one follow-up,
Yeah.
maybe then you can come in. Is that a competent authority will deal with an issue when both parties are in Saudi, or one is in Saudi and one is outside Saudi?
No, for now, because the competent authority cannot deal with companies outside Saudi Arabia. Okay. However, that's why for the competent authority or even for the law, one of the main conditions in order to collect data in Saudi Arabia, you have to register with the competent authority. So it means that I'm sure regarding the terms and conditions and for granting the license will be also very harsh. But again, the authority doesn't have the power in
Extraterritorial
order.
jurisdiction.
Exactly.
Yeah, please.
Just in addition to that, if you're interested, so most privacy laws like Saudi, but the GDPR also, they have this extraterritorial effect, which means that the GDPR is applicable, the privacy law Saudi is applicable in the country itself, but also companies located outside that jurisdiction that process data from citizens from, in this example, EU, they have to adhere to GDPR. And then your question, how can you actually enforce them? An outside company. So one of the obligations on GDPR is that companies, when they process the data from EU citizens, they have to have an EU representative in the EU with sufficient funds to pay the high penalties.
But what if one party is in India outside the EU? Then what happens?
One party outside
outside the EU, let's say it's somewhere in India or Sri Lanka.
Yeah, they have to register. They have to have an EU representative in the EU itself.
Okay.
And that is then actually, the point of contact for the supervising authority to go to.
It's complicated.
Okay, I really want to bring this to a close in the next 5 minutes or so. In order to do that, I'm going to ask you, Niyati, if you can give us, when you look the year ahead, and you think of the kind of privacy, cybersecurity challenges that could come across your interest working within Hewlett-Packard, can you give us your thoughts as to what's the thing that maybe worries you the most, or where you think, I'm going to have to invest my time over the coming year in this space?
I think the fact that we do not have a stabilized law as of now is something that's really worrying me in the near future that I'm looking at, and looking at the fact that laws get withdrawn and then through a tweet another law comes into place and it's just getting into position. So for the next year, this whole uncertainty that I'm looking at is something which I would ideally want should be resolved. The second problem is, okay, we can get that resolved, but will it cover, I'm somehow very cynical about this new bill as well, because I do believe, and I understand that you don't want data localization, but I do believe that a lot of aspects, let's assume GDPR is not though it should be, it's not the guiding force. I do feel a lot of aspects have still not been covered, right? And this whole hurry of the legislators to get something out, to ensure that it's in place so that something can start working, I think that should be a point of worry for all of us, at least for the next 1 year. We want a stabilized law. We want something that's comprehensive, something that ensures all the elements have been, taken care of. So I think that's what I'll look at.
Thank you. And Astrid, you're the only one I haven't as yet asked to look into your crystal ball. But over the next year, when you think about where your work might go, you're sitting here in Dubai. Have you got any thoughts as to where you think there'll be like a significant change for you, so that if we're sitting here in a year's time, you'll say to me, "Oh, do you know what I've had to do so much of in the last year"?
I think it would be more focus on data retention, data deletion, which is becoming more and more important every day. Because at one hand, in all those frameworks, you have this data minimization requirement, and the more data you have, the higher the risk of a data breach. So you want to delete the data the moment you are allowed to delete the data. And that depends on the local jurisdictions. So that then becomes a very complex thing, because every jurisdiction is different. If you look at tax data, finance data, HR data, corporate data, employee data, and being able as a global organization to kind of manage that the whole retention and deletion, that's going to be a huge issue.
Yeah. So, I mean, I deal with companies every day who are dealing with that issue, the complexities of how on earth you can get to grips with the requirements on the one hand to keep some data for 25 years or for its lifetime. On the other hand, the requirements, say, within, let's say, Estonia, to keep CCTV and data just for 30 days. And it is very challenging from that point of view.
Yeah, and in that respect, Damien, I have a question for you, if you don't mind. Now, having said all of this, I think it's very important for a company to be aware where the data resides within the company. And I think then, e-discovery tools will become more and more important. Could you elaborate on that, please?
Yes, so, many of you will have your data stored in the cloud now, your communications data, your email data. You may likely be using Microsoft Office or its Google equivalent. You'll have your documents stored in SharePoint online. You'll have your documents maybe stored in OneDrive for business. The getting to grips with unstructured data, and by that I mean data that doesn't have like tags applied to it, that tells you already what that data is. It's different. If you're looking in a database, someone's already said, well, that field is a date of birth. So if you need to say, where's the date of birth in this system? Well, it's called date of birth, and you can find it. Where's people's date of birth in emails? Where's people's date of birth in documents? That's an altogether more challenging subject. And so, for example, and that leads into really, e-discovery tools, which is basically a way of searching through data to try and find data that's relevant. That's one way in which you can look at data. That's normally further downstream, where you're, say, faced with litigation or an investigation, an internal investigation or a regulatory investigation, and the question is, well, what happened? E-discovery tools allow you insight to say, well, I'm going to search all my data and find the documents, then I'm going to review those documents and work out what the story is. So e-discovery tools are really an investigator's tool to get an understanding of the unstructured data largely that might relate to a dispute or an investigation. But I think that's downstream. I think upstream, in my view, like every company that has, for example, Microsoft Office, right, or Microsoft 365, which is its cloud variant of that, needs to be looking at how it is, for example, retaining data. You predicted around retention, data minimization. Well, for people who follow the way in which legislation is developing, look to California. So California, what I would call CCPA 2.0, so that is the California Consumer Privacy Act, as amended by the CPRA, which came into force at the 1st of January, that now introduces retention and data minimization as concepts that didn't exist previously in California, right? That's the 7th largest economy in the world, has now put in place a requirement for the companies that operate there that come within the thresholds, right? And you've got to come in the threshold. You've got to be like, it's like $25 million worth of business within California, so there's a threshold. But once you're at that threshold, and there's an awful lot of companies will be at that threshold, well, you're going to be immediately not compliant. unless you've looked at, well, what am I doing about my unstructured data? So if I had one thing that I would urge people to think about, it's go back and think about your data in the cloud, and think about that data in the cloud. How likely is it that if a regulator did knock on the door and say, what's happening actually about people's personal data in terms of like people who've left your company, people who were communicating with your company 5 or 6 years ago, what's going on with their personal data? And if your answer is, well, we've still got it, that's terrible. That's a really bad answer, right? The good answer is, well, we are currently starting a process where we are making an assessment, we're digging into our data to find out where that personal data is stored, and then we're going to put in place a set of robust retention policies around that, so that we might not have it fixed now, today, but we expect within 6 months, a year, 18 months, to put in place those processes and procedures, particularly focused around that data in the cloud, that Microsoft data in the cloud. And the point is, like if you're in Microsoft or you're looking at Google, they provide these tools, right? Use them. They're already there. You're already paying for them if you've got Microsoft 365. So use the tools, put in place retention. So that would be my final exhortation really for people in the audience. I wanted to really thank my panelists. I appreciate anyone who stayed the course. I've been counting over the course of the presentation, we've lost 17.4% of our audience share, which is disappointing, but for those who stayed, I'm really grateful. So if I could give my hand to my panelists, please, I'd appreciate that.
Thank you so much, Damien and panelists. Though this was the last session, and of course the people are a little tired, some of them left, but yes, the people who stayed here, it's wonderful having you all here as well. So though it was the last session, but of course an interesting one, so thank you so much, panelist and moderator. Now I would request Damien Murphy, our moderator for the session 5, to please present the memento to our eminent panelist. So I would request Niyati Oja to please come forward and accept the memento on behalf of World Litigation Forum. Pose for the photograph. Now I would request Astrid Govardhan to please come forward and accept the memento on behalf of World Litigation Forum. Now I would request Kesser Metuya to please come forward and accept the memento on behalf of World Litigation Forum. I'm so sorry. Now last, not the least, I would request Damien Murphy to please come forward and accept the memento on behalf of World Litigation Forum.
Thank you.
So thank you so much, panelists and moderator. With this, we come to the end of 2 wonderful days of World Litigation Forum. And so with this, I, Shruti Singh, Vice President, Business Development, World Litigation Forum, feel honored and privileged to get the opportunity to propose a vote of thanks on this special occasion. I want to extend my generous thanks to the entire guest who has come, though, of course, few of them left. So still, the people who have stayed till the end, thank you so much for staying till the end, who have come from long distances for their support and cooperation. I also want to thank all our speakers for adorning their necessary work and sharing outstanding presentation on some of the important topics in litigation industry for 2023. I'm also very much thankful to our sponsors, Rakesh, LexisNexis, BSA Ahmed, FTI Consulting, Minteso, Solid Legal Marketing. It wouldn't have been possible without your support to organize such a wonderful and successful conference. I'm also thankful to all our program advisory members. Words are not enough to thank their constant guidance and support, which has helped us to shape this conference. An event of this dimension cannot happen overnight. The wheels start rolling months in advance. We have been fortunate enough to be backed by a wonderful team of very motivated and dedicated professionals at World Litigation Forum. So I really want to thank them for their involvement that they have shown and their willingness they have expressed to take on the completion of tasks beyond their comfort zone. If time is money, then today you have spent millions for us. Thanks to all of you for making this event successful. We will be sharing the feedback forms to all of you, and we look forward to your feedback to how we can serve you better in the upcoming series for the World Litigation Forum. Our team will be sharing the photos and videos in 2 weeks' time. And with this, I'll conclude 2 successful days of 13th World Litigation Forum 2023 Dubai. And we hope to see you in Singapore and Amsterdam on May 23, 24, 2023 and June 27, 28, 2023. So with this, thank you, everyone. Thank you for joining us, and have a lovely evening. And I request the people I have requested for the short interview to please stay back. Hello, everyone. So we have Sabina Noreen Malik from Jane's Solicitor, United Kingdom, who attended the 13th World Litigation Forum 2023 Dubai at Pullman City Centre, Creek. So Sabina, you have attended the conference for 2 days, so just wanted to understand what your experience has been so far for the conference that you've attended.
Shruti, it's been a wonderful experience. I've met some outstanding litigators, I've met some outstanding lawyers, I've met outstanding experts. It's been a great platform to bring together people from varied professions as well as the legal profession. So I do encourage people to join the World Litigation Forum either as a speaker or just as a member of the audience. You will thoroughly enjoy your time. The 2 days has been a great experience. Thank you again, World Litigation
Thank you so
Forum.
much, Sabina. Thank you so much for joining us.
Take care.
Hello, everyone. So we have Daria Pastore from Ligans, Italy today with us, who attended the 13th World Litigation Forum 2023 Dubai on January 17 and 18 at Pullman, Dubai, Dera. So yes, Daria, so you have attended the conference for 2 days. So what has been your experience so far for the conference?
Thank you. The experience was amazing, really, because we discussed of many topics about and trends about litigation, international litigation, with lawyers, excellent lawyers, and general counsel from different jurisdictions. So, I mean, my experience is really positive, I would say, and it opened my mind more, and I learned a lot of new, trend about other jurisdictions. So I'm very happy of this conference.
That's wonderful. So, what are the few takeaways that you had from the conference?
Yes, as I stated, I mean, the new trends, I would say. So I can see more, the future of the litigation, international litigation. Then I met amazing people, and which is always, an important added value in a conference. And so I hope to stay in touch with this person from all over the world.
Absolutely. Thank you so much, Daria, for for joining us. Thank you so much. Hello, everyone. So we have Andrew Hart from Hart Giles, Hong Kong. So yes, so he attended 13th World Litigation Forum 2023 Dubai on January 17 and 18 at Pullman Dera, Dubai. So yes, Andrew, just wanted to understand what has been your experience like at the conference for 2 days.
Well, I should say this is the first conference I've ever attended from the World Litigation Forum. So it was a very positive event, and I would like to attend future events, but my difficulty is that I don't have any reference to compare it to other conferences. I think that all conferences that are starting again this year are going to be difficult to start the whole process again, because as I understand, for the last 2 years or so, we haven't been able to hold conferences because of the COVID situation. So I would say it's a very good start, and I hope that we can continue to build on what we've achieved at this time. We've met some very interesting speakers, some very interesting delegates, and therefore I think that the next conference that I will plan to attend is the one in Singapore, and hopefully we can then continue the work and improve the position, and hopefully can get one of the points I think is to get more people attending. Obviously, not everybody's going to attend every session, but if we can get a higher number of delegates to start with, I think that would be a very positive thing.
All right. Thank you so much, Andrew. Thank you for your feedback.
All
It
right.
was lovely having you at 13th World Litigation Forum.
Thank you.
See you again in
All right.
Singapore.
Okay, bye.
Hello, everyone. So we have Ankush Mehta he's a partner at Saril Amarchand Mangaldas, India. So he attended the 13th World Litigation Forum 2023 Dubai on January 17 and 18 at Pullman, Dubai. So Ankush, since you attended the conference for 2 days, so what has been your experience so far of the 13th World Litigation Forum 2023 Dubai?
Thank you, Shruti, and thank you World Litigation Forum for having us here. Thank you, Cam, for also having us here. And I think a couple of key takeaways. One is that it's a fantastic opportunity for us to exchange ideas on a common platform. We get to hear a lot of global perspectives as well. And more importantly, get to meet lawyers and other industry professionals from all over the world. So great, looking forward to the next one as well. So thank you so much.
So much, Ankush. Thank you for joining us and look forward to seeing you in Singapore. Hello, everyone. So we have Damien Murphy, he's a barrister at Lighthouse, United Kingdom. Damien attended the 13th World Litigation Forum 2023 Dubai on January 17 and 18 at Pullman, Dubai. So Damien, since you attended the conference for 2 days, so I just wanted to understand what has been your experience like attending the World Litigation Forum conference in 2023?
I think the hotel and the conference facilities are excellent. I very much enjoyed the food, which is good. Your role in it and how kindly you were when you looked after us and made sure everything was working, I really appreciated that. My fellow panelists, once we managed to get together, it was quite logistically difficult to get everyone together. It really is hard if you've got 4 different people in different time zones to get the time, and they're all working as well. So I'd say that's one of the difficulties about a panel, is that you probably want to try and do a run through in advance. I mean, I'd like to think ours worked, but it's always a little bit risky if you haven't had a chance to sit down with people. So trying to get the panel together as soon as possible would be a good tip. And then it's hard just to get audience interaction in any kind of conference. It just is always difficult. But it wasn't for lack of trying, and as I say, I really appreciated all the work you did for us.
Thank you so much, Damien, for joining us at World Litigation Forum. Thank you for your lovely feedback as well. Thanks a lot. Thank you so much. Hello, everyone. So we have Niyati Ojha, who is legal counsel at HP India. So Niyati Ojha attended the 13th World Litigation Forum 2023 Dubai on January 17 and 18 at Pullman, Dubai. So yes, Niyati, so since you attended the conference for 2 days, so what has been your experience so far about attending the World Litigation Forum conference in Dubai?
Thank you. Thank you, World Litigation Forum, for first calling me here, inviting me here. This is the first time I've attended a WLF summit, and I should say I'm not at all disappointed. I think one of the very good things from this session has been that we got an introduction in a lot of subject matters, right? Without really going too much in depth, but we understood a lot of subject matters. The speakers were very informative, what they were trying to tell us, what they were speaking about, and the networking session really helped because whatever they spoke about and during the panel session was actually elaborated during the networking break. So all in all, I think it was a great session. It was really good, and I'm hoping to attend more such sessions in the near future.
Absolutely, absolutely. Thank you so much, Niyati, for joining us at WLF 2023 Dubai. And we look forward to seeing you in the future conferences.
Lovely. Thank you so much.
Hello, everyone. So we have Renata Berzinskin from Orland, Lithuania. She's legal counsel there. So Renata attended the 13th World Litigation Forum 2023 Dubai on January 17 and 18 at Dubai. So Renata, since you attended the conference 2 days, and so just wanted to understand what has been your experience like attending the conference?
Yes, thank you. For me, it was very important to know about these international topics because this topic of legal risks in this emerging environment and changing political situation and especially this enforcement of foreign arbitral award topic. These are very broad, covered many jurisdictions, and for me was very, very important, especially also discussion about force majeure items, about hardship, about also data protection. These are general topics which we need all lawyers, especially in-house lawyers, to know. And also, as I personally came to this area first time, for me was very important also to know about UAE, also legal environment, and I found new friends, and it's very, very important because now we have a connection at my company with Aramco, and we are buying oil from Aramco. So for me, it's very important personally to know about jurisdictions.
So, what are the key takeaways that you had from 13th World Litigation Forum?
Yeah, so compliance issues that in our company we need also review compliance and policies and make the best practice we got here. Also, I got a good network of people whom I can contact in order to meet and talk with them.
Right. So thank you so much, Renata, for joining us at 13th World Litigation Forum and being there. So we look forward to seeing you again in the future conference. Thank you so much,
Thank you.
Renata.
Bye.
Hello, everyone. So we have Astrid Govardhan, Legal Counsel, VFS Global Dubai. So Astrid attended the 13th World Litigation Forum 2023 Dubai on January 17 and 18 at Pullman, Dera City Center, Dubai. So Astrid, just wanted to understand your experience that you have gained at the World Litigation Forum.
I think it's an excellent event to meet like-minded people and meet specialists from all over the world and connect with them. So thank you for hosting that.
Thank you so much. Thank you so much, Astrid, and we look forward to seeing you in the future conferences. Thank you for joining us. Hello, everyone. So we have Kaiser Matawa, who is the managing partner at Dr. Kaiser Matawa Law Firm, Saudi Arabia. So Kaiser Matawa attended the 13th World Litigation Forum 2023 Dubai on January 17 and 18 at Pullman Dera City Center, Dubai. So Kaiser Matawa, just wanted to understand what your experience has been like attending the World Litigation Forum conference.
Thank you very much for having me here, and thank you very much for organizing this event. And it's been a wonderful event. For me, it's been a great experience, meeting lawyers from all over the world and actually attending very nice sessions. I have learned a lot, and thank you for doing this.
Thank you so much for joining us, and we look forward to hosting you again.
Thank you very much.
For the future. Thank you so much. Hello, everyone. So we have Zubair Makhdoumi he's a regional manager, Rakesh, European CIS. So Zubair Makhdoumi has attended the conference, 13th World Litigation Forum 2023 Dubai on January 17 and 18 at Pullman Dera City Center, Dubai. And also Rakesh is the exhibitor at the 13th World Litigation Forum 2023 Dubai. So yes, Zubair, since you attended the conference 2 days, so just wanted to understand that what your experience has been like attending the conference.
Rakesh has been a part of World Litigation Forum for well over 2 years now. We had in participation the last year as well. Rakesh belongs to the Government of Ras Al Khaimah. We are the foreign direct investment branch of Government of Ras Al Khaimah. So our aim to be a part of World Litigation Forum was to connect with different lawyers across the globe, because these lawyers are always in the advisory services for their customers to help them open up their international businesses. So that was the prime goal, to be a part of this conference, and we've had a great experience. We were able to connect with a lot of like-minded professionals whom we'll be contacting now after the event for different partnerships and for the benefits that they bring into the FDI of UAE in general and Ras Al Khaimah in particular.
So Zubair, what are the key takeaways that you had from the conference?
There were very lovely case studies that were discussed from a litigation point of view these days, very open-ended conversations, and you get to learn a lot in terms of how litigation is happening globally.
and what are the key takeaways in terms of the cases that are happening from a corporate point of view. So overall, it was a very nice exhibition in terms of what litigation stands for globally. And like I said, we met quite a few very senior lawyers as well, and they were able to give us a lot of key takeaways in terms of how the world legal system is currently behaving, specifically around cybersecurity, and how the laws and litigations have swamped in terms of the changes post-COVID and the pandemic.
So, Zubair, would you be recommending the World Litigation Forum conferences to your friends or colleagues?
Of course, yes. I mean, we do talk to a lot of. It's a very small business community in UAE in general, and there are a lot of recommendations in terms of what people ask us. And yeah, I'll be recommending to my lawyer friends, because I personally work with lawyers from around 15 different countries, and I will be advising them to be a part of the conference next year. I presume you're going to some international jurisdictions as well as the next steps, and we'll be glad to recommend lawyers and like-minded professionals to be a part of this.
So much, Zubair, for joining us. It was a pleasure hosting Rakesh at World Litigation Forum, and we look forward to seeing you again in our future conferences.
Thank you, Shruti.
Thank you
Thank
so
very
much.
Thank you.